issues, despite this, it issues it for delivery of motion. I'm not saying whatever may be the result of the appeal, but this is not proper. At least when your Lordship has heard the matter finally, and this at least could not have been.
You will get the judgment in a couple of days.
But this was not proper. This is what.
Yesterday only it was not. Anyways, we'll see.
अवार्ड मैटर था 13 के लिए फिक्स है, लेकिन टेकअप नहीं होता है। मेंशन किए थे पहले भी था।
नहीं हो पाएगा ना, सिविल मैटर्स में टाइम लगता है।
ये 13
नहीं हो पाएगा, इतना स्पीड नहीं होगा, नहीं पॉसिबल। You have to wait for your turn. Just handle.
अवार्ड मैटर हुजूर बोले थे कि मेंशन कीजिएगा 2 सप्ताह के बाद, 3-4 सप्ताह के बाद।
कोई बात नहीं।
From date is attempt on second appeal 484 of 2003.
You were giving some judgment.
Yes.
You were also giving some judgment yesterday. You were also giving some judgment yesterday.
Yes. Before that, I'll only take 5 to 10 minutes. I'll not waste your words. I'll keep my submission very short. I'll just summarize it. Your Lordship may kindly take a plain and written statement and 1 or 2 portions of the evidence that was in the judgment. Because there are 2-3 questions which are falling from your Lordship that I have to answer. First, the right of the plaintiff to institute a suit in the capacity of a power of attorney.
No, that is not the issue.
Then,
They have just pointed out that is not
Yes.
the issue. The court has given a finding that he was depressing. You forget that.
because I fall within the definition of the landlord in terms of the rent.
That's it. There is no-
So,
that is not the issue.
yes.
That is not the support.
Then another fact was that your Lordship, yesterday itself I pointed out that half of my case is based on admissions made by the dependent owner. Now, original owner admittedly was Sabira Bibi. He himself said she was a lessee of a Khasman property. And this important fact is the most important fact. Sabira Bibi is the grandmother of the persons who had given power of attorney to Matlub Alam. And Matlub Alam is none other than the son of the eldest one, that means Saleha. His own son, her own son. Of the Saleha, the 3 ladies, of whom one is the son. So this is one fact. Now, the property originally was a leasehold property in the name of Sabira, and when the lease was renewed, then it was renewed solely in the name of only one daughter instead of 2. There were 2 daughters.
Is it a renewal or a fresh lease?
It was renewal, and that was the reason that when a partition suit was
That lease deed has been exhibited.
in 1985, this lease was renewal or whatever, but it was not a
Has it
ground.
been exhibited?
Yes,
Exhibit
it
number?
is there. Exhibit
8 and 8 and
8, only 8. But before that, I must also point out that it probably does not show as a renewal. It does not show as a renewal. But the original lease was of the Sabira, and then this lease was by one of the 2 daughters. This lease was fresh lease, or there's no case of fresh lease was granted. This is not correct. Lease was executed in favor of Khalif. This lease is the year 1985, and then we have very specifically stated in our plate also, and that fact has not been disputed, that we filed a partition suit three means the three DTs they filed the partition suit, and in that a compromise was entered in. Now, what ultimately a compromise decree was passed or not, that document we have not. So, but a compromise was entered into in which Kanij Fatima, who was a lessee in 1985, she signs. Her signature is there, and a map is also appended to the same petition, in which also she signs.
This
And
petition is which petition?
that
Compromise.
compromise between the plaintiffs, the three ladies, and Kanish Fatima and others. Exhibit 1. Exhibit 1. And where it bears the signature of Kanish Fatima. And now the statement here, I'm not claiming any title. Here they themselves say that Sabiran TV had inducted them as a license. This is their plea. Now, and they have paid license fee firstly to Sabiran and then till Kanish Fatima they have paid license fee. This is their
They have
whole
paid
plea.
license fee to Kanis Fatima.
Yes, this is their whole plea. And now, interestingly, now based on these facts, only 2-3 statements made in the plaint and then its rebuttal in the statement, in the written statement made by him.
You are referring to para number.
My learned friend points out,
क्या चीज?
ये बोल रहे हैं कि पूरा प्रॉपर्टी किसी और को लीज हो, but I'm not.
ठीक है
If you jointly say that it is not to be argued, you withdraw.
नहीं
नहीं आप this is lordship for me to appraise this court since lordship my client was under open heart operation today he has brought this new lease in favor of the son of Kanis Fatima which was executed in 2021-22 right from 2013 for 30 years therefore lordship whatever decided in this court it will bear no fruit for the plaintiff that is one thing lordship and secondly we have filed a reply in the second appeal stating there giving information to the court that the other two persons from whom they have got the plaintiff has got this power of attorney has already expired. They have not filed anything. It is already filed in 2022 itself. अब बचा क्या है इसमें? Thereafter हम सब इतने अपने आर्गुमेंट में ले आए हैं.
हाँ ये वाला तो फैक्ट वो फ्रेश लीज वाला एक डिफरेंट फैक्ट है.
वो हम जो चीज मेरे रिकॉर्ड में नहीं है उसको हम
How that I have stated lordship, though audio is not in the record, but only to appraise this honorable court since no degree cannot be executed, there is nothing because the original landlord. कल तक हमको तो पता
नहीं कल हमको हम तो पूछे हमको ऐसा कोई बात ही नहीं बोल रहे.
नहीं this is the original certified copy I have got.
नहीं अगर
He is the son of Kanis Fatima, therefore she has not come to depose. The mother has not come to depose. All the three ladies has not come to depose, and power of attorney holder without impeding the original persons as a party.
We will only decide the substantial question of law.
Yes.
I'm not bothered.
Landlord and tenant vis-a-vis plaintiff.
I will not.
I'm confining my entire argument on BBC lordship, no other.
We will not enter into all these kind of
Yes,
that you are, both of you are saying.
But lordship, the persons who are died, we have already given their applications.
They are not parties. They are the landlord in terms of rent control act. That is
You are landlord. How you are landlord? You are the power of attorney holder.
One person is still there.
One person is there, but the power of attorney was of 3 persons.
That's it.
2 persons were already expired.
So
First, your lordship, we must see the
that is
definition of
my
a landlord in rent control act. Your lordship must see that. That is my pleading.
you see, I will only decide the substantial.
No, your lordship may decide, but your lordship only to satisfy
And I have also confined
a
my
question
argument
which
with that.
a question which is being raised, that your lordship may say. And it will always be a matter between me and the persons who are giving me power. definition of landlord. Landlord includes a person for the time being is receiving or is entitled to receive the rent of a building, whether on his own account or on behalf of another, or on account of behalf of benefit of himself or others, or as an agent, trustee, executor, administrator, so and so, who would so receive the rent to be entitled to receive the rent is the building. So I squarely fall within the definition. And what is my statement made in
If the executor of the power of attorney dies, then also he is entitled to collect the rent.
Because if I continue to realize rent and I am realizing rent from him, then I continue to be the landlord for the purpose of only for the purpose of the satisfying the definition of the landlord. So it would always be a matter between me and the persons who have. I cannot claim my right vis-a-vis my own persons who are the landowners who have given me the power. But I
So irrespective of the death of the person,
Yeah,
the
they-
power of
they-
attorney will
power
continue.
I would continue to be a landlord in terms of, because now if their descendants, they do not, they allow me to continue or to collect rent from the person, then I continue to be the landlord.
Not necessarily. When there is a specific power of attorney executed by a person, which is like, wakalatnama. The person dies, story is over.
Power goes.
Power
The power
goes.
would go, but the authority here, there is an implied authority that you collect rent from the persons. So I would squarely fall within the definition of the land. Because I am entitled to.
Irrespective of the person, whether the executor is expired or not.
Absolutely. Irrespective of that. And even otherwise, one of the person is still alive, as per his own statement.
Who has expired?
I have given the names, not sure.
In your written agreement.
अभी
First time पहले काउंटर
पहले क्या हुआ उसमें मैं
कल क्या कर रहे थे? कल तो नहीं पता एक बार भी कोई मर भी गए.
नहीं, it was mentioned yesterday and it was fixed as a first case lordship and I was not well. Therefore, the पूरा हम फाइल नहीं देख पाए थे. कल रात कुछ समय दिए देख लिए, it was for me to appraise this court. And it is already on record.
Just a moment.
It is also
if
with
you had
them.
any difficulty, there was no. I don't insist that you should argue. Why should I insist? If there is any difficulty at your end, and if the matter is being taken up out of turn, कोई आपसे बिना consent के तो नहीं हुआ matter.
मैंने हमसे पूछा नहीं गया.
But you agreed to argue ना? कल पूरा दिन हम लोग argue किए हैं.
हाँ किए हैं.
So yesterday you never said that you are not ready or it's a very
हमको
short
बोलना उचित
notice
नहीं
or you are not
Since
ready.
lordship वो रिकॉर्ड में था, इनके पास भी था. With clean hands उनको बताना चाहिए था कि ऐसा पिटिशन फाइल हो चुका है 2022 itself. आज का नहीं है पिटिशन फाइल किए हैं. And except सलेहा छोड़ के दो का डेथ हो गया.
नहीं. Saleha is my mother who has died. So naturally I inherit Saleha's.
And one more.
And one more. So there are two persons.
One is alive.
One is alive.
One is alive.
One is. And this
तो
Yes.
मतलब राम को बताएंगे कौन मर गया ये और एक और मर गया अब हम रिकॉर्ड खोजते
अरे
रहेंगे.
नहीं हम लिखे हुए हम बताने वही खोल के बताना चाह रहे हैं अभी बता रहे हैं.
Saleha and Khairun.
That is paragraph पेज 3 और पैराग्राफ 4 ऑफ माय रिप्लाई. और इसमें भी हम लिखे
Page 3 of para 4.
और रिप्लाई में हो इसमें नहीं, इसमें भी दिए.
कहाँ?
हाँ पेज 8 ऑफ माय रिटन आर्गुमेंट. लास्ट ये नोट हम लिख दिए हुजूर, उसमें ये लिख दिए हैं कि इट इज नॉट प्लीडेड बट दिस इज द करंट पोजीशन सिचुएशन.
इनको कंप्लीट कर लीजिए. You say that.
Can I continue or?
नहीं नहीं,
आप सामने
let him
चले
conclude
नहीं,
thereafter.
वो नहीं. I don't want to waste your lordship's time. So, if your lordship posts it on some other day.
No, what
नहीं,
some
तब
other
ठीक है.
day? What do you mean other day?
हम कोई ये नहीं, हम
Other day
इसमें
कल ही हमको रिजर्व कर लेना चाहिए था. बहुत गलती
अरे
की क्या
हम नहीं टाइम मांग रहे हैं, हम टाइम नहीं मांग रहे हैं.
Other day.
हम टाइम नहीं मांग रहे हैं.
टाइम मत मांगो.
हाँ,
अब
बस
इनका
ठीक.
जो ये है
तो ये
point that 2 persons have died, you kindly respond to that.
Yes.
Firstly, मरने के बाद तो I will not agree that you continue to be the landlord.
नहीं, वो क्यों हम बता रहे हैं. हम directly answer.
Yes.
Here, power of attorney is different and the landlord is different. Here, whether I am entitled to receive rent or not, whether on my behalf or as an agent or not, this is one fact. So I can be on several accounts, I can be entitled to receive rent. So if I was acting as agent of the entire 3 daughters from 1980 itself, and I was collecting rent from the tenant, that is my plea. I was collecting rent from my tenant. So if I was collecting rent from the tenant, and I could have also inducted tenant also, then I continue to be the landlord in terms of rent control land. And if 2 persons die, then one is still alive. Even one co-owner can file a suit for eviction. One is still alive.
When did these 2 persons die? Before the suit or after the suit? I mean during the pendency of second appeal.
Yes, yes. 2003 का second appeal है उसके बाद, क्योंकि they have also filed a second appeal only in the name of मतलूबात. इसमें भी नहीं लिखा है through the power of attorney holder.
That's it.
Everywhere it is there. एक दो point और उसको correct let him complete.
And second one is the mother of the or plaintiff himself. So I would not give power of attorney to myself. I would not, because I have stepped into her shoes, even other. So there are.
So you are the son of one of these ladies.
Yes.
Your mother's name is
Saleha.
So otherwise also you inherit her property.
Yes. And even one owner would be entitled to maintain a suit for eviction. I would not have exclusive right on those property vis-a-vis my own massees and aunties. I would not have. But for the purpose of prosecuting this suit, I continue to be the landlord. I have rightly filed the suit and I have rightly filed the second.
This is on the point of death.
Yes.
The learned counsel for the respondents has pointed out that as back as in the year 2022, it was brought on record by filing an application on 12/10/2022 that out of 3 daughters of Sohra, two of them, namely Saleha Khatun and Khairu Mirza, expired during the pendency of the second appeal. It is further not in dispute that the plaintiff is the power of attorney holder of the 3 daughters of Sohra and is also the son of Saleha Khatun, The learned counsel for the respondent has submitted that, therefore, on account of death of two of the persons who had executed the power of attorney, the second appeal on behalf of dead persons cannot proceed. The learned counsel for the appellant has submitted that in a suit seeking, in a suit of landlord-tenant relationship, the right to collect rent is to be seen. He has referred to the definition of landlord as defined under the JBC Act and has submitted that admittedly one of three sisters is alive, namely Ashrafu Nisha, and therefore it cannot be said that the power of attorney has completely lost its force. In addition to this, he has also submitted that the plaintiff is the son of Saleha Khatun, and therefore he also inherits the property. This will take. Yoga, our next point.
There was a dispute that what happened after there are two more. Whether the tenant, the defendant is a tenant or a license. This is one of the main issues.
Yes.
तुम कह रहे हैं कि टेनेंट हमको मान लिया जाओ। I'm only confining my argument to this, yeah.
ठीक है
Licensing का
Should
licensing
I record that you should be acknowledged as a tenant?
नहीं हमको आर्गुमेंट करना करें because now
आप बीच में बोल रहे हैं इसीलिए पूछ रहे हैं आपसे.
नहीं कर let this be.
नहीं अगर मान लेंगे तो ये पूरा
Because
मैटर
this
ही
AR case developed on the BBC Act है. Licensing तो लीज यहाँ है क्या कोई भी टर्म यूज कोई भी very candidly I am speaking not
नहीं अगर ये इजी हो जाता
therefore I am speaking जब यहाँ लीज का कोई
understand. Now here there is one I must also consider law because we must be clear in law at least. There are because yesterday one point had arisen as to what would happen when there is a there are two kinds of one is lease and one is license. The difference between lease and license, one judgment of Honorable Supreme Court is very important. What would be the difference between the lease and license? That may kindly be seen.
Just a
Yes. Only for clarity and listening.
This lease can be interchangeably used as a tenant? Yes.
Lease would be of two kinds. Lease, if there is a lease, then there are further two categories. It can be of vacant land also, and the lease can be of building also. So if the lease is of a vacant land, then the right of the lessor would accrue only on the basis of transfer of property. I cannot file a suit. My suit under EBC Act or Rent Control Act will not give me. But if there is a license, then what would happen? Then if there is a license, then what are the conditions? License in fact is a lesser right of the person who is claiming himself to be the licensed. That does not give him protection under the rent control. If he claims himself to be the licensee, he does not get the protection of the rent control. So here is a case where the Honorable Supreme Court has, in this case, in a tenants where a person was claiming himself to be the tenant, and not the licensee. The matter travelled up to the Honorable Supreme Court, and here the Honorable Court in this head note itself, Your Lordship, because portions of it have been taken from the judgment itself. What was held was in page 181. These have been defined in section 105 of the Transfer of Property Act. The essential elements of the lease are the parties, the subject matter or renewable property, the demise or partial transfer, the term or period, the consideration or rent. The relationship of lessor and lessee is one of the contract. When the agreement vests in the lessee a right of possession for a certain time, it operates as a conveyance or transfer and is a lease. That means only if there is a transfer of right to possession. This section defines lease as a partial transfer, that is a transfer of a right of enjoyment for a certain time. This is very important for lease or tenancy under either Rent Control Act or under the Transfer of Property. Whereas license is a power or authority to do some act which without such authority would not be lawfully done. In the context of an immovable property, a license is an authority to do an act which would otherwise be a trespass. It passes no interest. This is very important. It passes no interest and it does not amount to a demise, not it gives the licensee an exclusive right to use the property. The definition in the Rent Act includes a person in occupation under a subsisting agreement for license and gives the person exchange. So here the licensee gets a licensee actually does not get any right in the property. Whereas in lease, he gets a right to possess the property and that right continues till he is evicted in terms of either Transfer of Property Act or under the Rent. This is the major difference. And one fact yesterday it had come that I must concede that license can also be of flat, or this was a case of flat also. Not necessarily it has to be of but here, in the instant case, the admission of the defendant himself very clearly shows that it is a lease itself. That means, what he says in his written statement, that the property was given to me by Sabira and she said that you continue to remain in this property, you make constructions and I'm giving this property to you, and therefore there was a transfer of possession and a particular right in the defendant.
So at best it's a lease of vacant land.
Vacant, yes.
Not a building.
Yes, yeah,
Not a
absolutely.
building.
This is
And if it is not that of a building, then how does BBC Act come?
yes. That is the second question. Now yesterday I
Just a
pointed out.
Please hold on. The learned counsel for the appellant has admitted that there is a legal difference between a lease and a license. Both lease and license can be of a vacant land or a building. He submits that the terminology used may not decide, but the intention of the parties and the nature of transaction between the parties would be key to decide as to whether it's a lease or a license. It is not in dispute from the side of the appellant that if the lease is that of a building, then under such circumstances, it is tenancy and will be covered under the BBC Act. He has referred to the judgment passed by the Honorable Supreme Court reported in bracket 1991 bracket close to SCC 180 and has submitted that the distinction between lease and license has been considered by the Honorable Supreme Court in paragraphs 16, 17 and 24. And also discussions in paragraph 12, 13, 19 and 15, which reveals that in case of a lease, there is a transfer of right to possess in exclusion of the others. But in case of license, there is no exclusive right to possess or to enter the premises. And in absence of a license, the entry into the premises would amount to trespass.
Now, to answer the second question, what would happen if this is a case where this is of Patna High Court 2007 PLJR, but it has relied on earlier judgments also. So here there is a reference of earlier our own Patna High Court prior to 2008. Para 17 is in. So far as the question of applicability of the Act in the instant case is concerned, the claim of the defendant petitioner is that in the description of the suit property given in the schedule of the plain, only 2 kathas of land is mentioned, but from perusal of statement made in the plain, specifically para 7, and also the lease agreement and the schedule attached thereto, it becomes quite apparent that there were several constructions on the land in question which was admitted by the defendant in the agreement. Hence, it clearly covers within the definition of a building under section so and so, according to which building means any building, hut or so and so, so and so. This view finds support. This may be skipped, this portion. Then, after the 2 judgments that have been mentioned, then it may be noted in this regard the above decision of the apex court with respect to Tamil Nadu so and so, but section 2 of the Act is exactly the same as section 2B of the Bihar Act. Even in a case where the original premises was a vacant land and subsequently the tenant makes construction and pays rent for the entire premises, the said premises cannot be legally called a vacant land and cannot be legally deemed to stand out of the definition of a building as provided under section 2B of the Act. This view I find support from a decision of this court in so and so, so and so. In the aforesaid facts and circumstances, which is hereby the provision that the Act will be applicable to the facts. So here also, in our case, yesterday your Lordship took note of the fact that the defendant himself in his own evidence has admitted that he was paying rent for land as well as building. Very specific admission made by him.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in 2007 SCC Online Patna 180 in bracket Hindustan Petroleum Corporation Limited versus Rajeshwar Prasad, and has referred to paragraph 17 thereof, and has submitted that even in a situation where the vacant land is involved, by making a lease or right to hold, right to possess, and subsequently the tenant makes construction and pays rent for the entire premises, the said premises cannot be legally called a vacant land and cannot be legally deemed to stand out of the definition of building as provided under section 2B. Under section under the definition of building as defined under the JBC Act. Building का definition also.
हाँ,
The learned counsel has submitted that in the same case, the Tamil Nadu Building Lease Rent and Control Act 1960 was involved, and the court found that the same definition was used under the Bihar Act. The learned counsel submits that there is evidence on record to show that the defendant had admitted that after he constructed over the property, he has been paying rent not only for the land but also for the building. And therefore, the suit premises involved in this case cannot be taken out of the provisions of JBC Act.
Now, last point. The point is that till Kanish Khabima, they have admitted that license fee or rent was being paid.
Yes.
My statement made in para 2 may kindly be seen. And the answer in, let us say,
Paranormal.
para number 2. Town customer holding number so and so, and all the description of land originally belonged to Musamad Sabiran Bibi, widow of so and Saleha Khatun, Asarun Nisa, Khairun Nisa are the granddaughters of Musamad Sabiran Bibi. Musamad Sabiran Bibi died leaving behind two daughters, Sohra Khatun and Kalish Fatima. Saleha Khatun, Asarun Nisa and Khairun Nisa are the daughters of Sohra Khatun. They filed a suit for partition of the properties of late Musamad Sabiran Bibi, which was registered as title partition suit number 31 of 1987 in the court of sub-judge at Chaibasa. In the aforesaid suit, a compromise was arrived at between the parties on 27/11/1989. The compromise was signed by the plaintiff and attorney of Saleha Khatun, Asarun Nisa and Khairun Nisa. The property described above was allotted to the aforesaid Saleha Khatun and others, and the decree was drawn. Now, then in para 4 we have stated that the plaintiff therefore as attorney of the landlord started realizing rent from all the tenants and including the present defendant. And then other statements are then the written statement may kindly be seen. The answer to the statement made in para 2 is para 13 of the written statement. That the statement occurring in para 2 of the plaint are not wholly correct. Sabiran Bibi had a daughter named Kanji who is still married with so and so. It is denied that the holding belonged to Sohra Khatun alone. The word Siyanochi may kindly take. It is denied that the holding belonged to Sohra Khatun alone. It was not a claim that it belonged to Sohra. It was belonged to both Sohra and her sister, Kanish, alone. Muhammad, so and so, and all these may kindly be skipped. Then, para 14 statement of fact is there. Para 15 again, para 2 is being answered here also.
Sohra Khatun is one of the sisters.
Sister of Kanish Fatima. Sister of Kanish. That means the Sabiran had two daughters, one Kanish and one Sohra,
That's
and mother of the three.
okay. Please write. Mohammed Ismail, husband of
I'll read that.
Sabiran. Sabiran है कि Sabiran है?
Sabiran.
अच्छा. Stepson.
Then this is not relevant, but I can read it. Musamad Ismail, husband of Sabiran Bibi, had a stepson, Musamad Ayub, alias Fakir Muhammad. Fakir Muhammad had fought long litigation with his stepmother relating to this holding. Similarly, there was a long litigation between Saleha Khatun and Kanish Fatima with regard to holding number 939. So here I'll pause. This is the same litigation which is referring to, which I have stated in para 2 of my statement. There was a litigation between the two branches with regard to holding number 939. The plaintiff has suppressed the real fact and has come out with a false case of right title interest over the sued property and over the holding in question. The defendant is setting forth the relevant fact, and all these facts yesterday I had read. Shall I read the entire?
No.
Your Lordship may then turn to page paragraph 50, because here state with regard to para 2 of my statement and plaint, it is being dealt here with. That with regard to statement occurring in sub-para of para 2 of the claim, the answering defendant submits and states that he has no knowledge of any partition suit. The defendant has no knowledge even of any alleged compromise arrived in the suit. The defendant was never included in the suit. However, such compromise as alleged is neither legal nor valid. The defendant denies all the statement made in so and so, and then the defendant reserves his right to submit additional written statement after the document referred to by the plaintiff are filed in court and the defendant gets an access thereto. This defendant has neither any knowledge nor any intimation about the alleged allotment having been made in favor of Saliha Khatun and others. Saliha Khatun and others on their behalf never apprised the defendant of the fact statement in para 2. Why I am referring to this is, I have disclosed in my plaint in para 2 the case number which is pending in the same court, specific case number, and I have mentioned that I have compromised, and I have also mentioned that pursuant to the compromise there was a decree that was drawn up, although I have not brought a decree, but this statement was not specifically countered. They should have said, or they correspondingly they ought to have brought any evidence that no, this the statement of fact made by me in para 2 was false. Then para 16 also is after 4 lines. The answering defendant has stated hearing above has no knowledge about any partition or allotment of property as described by the alleged partition is neither valid nor binding upon the defendant. The said partition cannot affect the interest of the defendant over the properties in his possession. It is strenuously denied that this defendant ever held the property as a tenant under Khalkani's Fatima. This statement may kindly be taken note. It is strenuously denied that this defendant ever held the property as a tenant under Khalkani's Fatima. There never came into being any relationship of landlord and tenant between defendant and Khalkani's Fatima. This also is being taken. Then next last after 4 lines, Saliha Khatun and others or plaintiff or the said Khalkani's Fatima have never acted or could not have acted as landlord of the tenant.
This statement is the last statement of para 16.
Yes. Just 3 lines of para 16. Last 3. Saliha Khatun or others or plaintiff or the said Khalkani's Fatima never acted or could not have acted as landlord of the tenant.
So what do you want to derive out of this?
And then,
There is no admission as such.
now, once I have stated, I have read evidence and I have made a statement that this was the partition suit in which there was a compromise, and I have mentioned and I have said that a decree was drawn up, then it was for them to have shown that decree.
You were supposed to bring
No,
the decree on because
it was on me.
it was on you.
Now, yes. Now,
They
their
have to
own.
prove your decree.
Yes.
Isn't it?
Now these facts coupled with the last statement of which I had placed yesterday, which your Lordship also took note of, that the defendant himself says that I have said that they are not paying rent after 1990, and I have also made statement in my para 2 of the plaint that a compromise was entered into in the year 1989, and after 1990 they are not paying rent. They come up with a case. They say that Kanish Fatima did not accept rent after 1990. Now, what he says that till 1990, Kanish Fatima accepted rent, but thereafter she refused to accept rent. That clearly, all these facts collectively show that because there was a partition and the property was allotted to me, and therefore Kanish Fatima refused to accept rent of the premises which have been legally allotted in my share. This is the case.
The learned counsel for the appellant has referred to paragraph 2, 3 and 4 of the plaint. To submit that specific statement was made by the plaintiff that there was a title partition suit number 31 of 1987 which ended up in a compromise between the parties on 27/11/1989 and a decree was drawn up. And that 3 tenants, including the present defendant, Narayan Sao and Kutubuddin, were in occupation of the property as tenant under Kani's Fatima. And after partition, all the 3 tenants agreed to atone Saleha Khatun and others as landlord in respect of the house and the premises in their occupation. And thereafter, the plaintiff, being a power of attorney, started realizing rent from all the tenants, including the present tenant. He has then referred to paragraph 13, 15 and 13, 15, 16 and 17 of the written statement and has submitted that the defendant took a plea that the holding did not belong to Sohra Khatun alone and that there was long litigation between Saleha Khatun and Kani's Fatima with regard to holding number 939. The learned counsel submits that this litigation essentially is referable to the partition suit which has been referred to in the plaint. The learned counsel has further submitted that the factum about partition suit and the compromise has been denied in paragraph 15 of the written statement, and at the same time in paragraph 16 the defendant has stated that he has no knowledge that any partition or allotment of property he has no knowledge of any partition or allotment of property as described by the plaintiff. It was denied by the defendant that they ever held the property as tenant under Kani's Fatima and that there was any relationship of landlord and tenant between the defendant and Kani's Fatima. The learned counsel has also submitted that during the evidence it has come to light that the defendant paid rent to Kani's Fatima till 1990 rent to Kanis Fatima, and in the year 1990, Kanis Fatima refused to accept rent. He submits that this conduct itself reveals that Kanis Fatima ceased to continue as a landlord, and since the property was allotted by way of compromise to the three sisters, they acquired the status of landlord, and the rent was being collected by their power of attorney, who is the plaintiff before the court. Okay?
एक para 10 of the deposition, your lordship have taken note of
Para 10 of deposition of
the defendant witness.
DW,
He is himself the defendant.
DW1.
Yes, DW.
Para 10 cross
Para 10.
examination or chief?
Cross examination.
He has referred to paragraph 10 of the cross examination of DW1.
1990 के बाद हमने फी देना चाहा, तो कनीज फातिमा बोली इसके लिए मुकदमा चल रहा है, फैसला के बाद जो निर्णय होगा वो दूंगी। मुकदमा के बारे में 1990 में मुझे जानकारी नहीं दी, या नहीं बताई कि किस के बीच में मुकदमा चल रहा है। इस 6 वर्षों के अंदर, that means from the date of 1990 this witness was being examined, 6 वर्षों के अंदर मैंने नहीं पूछा कि मुकदमा की स्थिति क्या है। And last, only last, that 2 witnesses, there were 3 tenants in my entire case. I have mentioned that there were 3 tenants, out of whom one was Kutubuddin, whose own son has come to depose. So he was the best person who said that our landlord of all the 3 persons, the plaintiff was the landlord, and we entered into compromise with the plaintiff and we have handed over. And the Ibrahim Mistri, the defendant, was also a tenant. So he is an independent. And he was the best person to have said that whether there was a landlord-tenant relationship.
Ibrahim Mistri is the defendant here.
Ibrahim Mistri is the defendant.
In this case,
Yes, yes. In this
his name is Ibrahim Mistri.
yes.
Yeah, Ibrahim.
Ibrahim Mistri.
Kutubuddin is of different eviction suit.
Against Kutubuddin, eviction suit number 3 of 1991 was filed.
And he
That
compromised
judgment and decree
He
was.
tendered in a compromise.
Yes,
And he
that-
acknowledged the tenancy.
Yes.
He is a tenant.
Okay.
And his own son,
It is in the same building.
एक ही जगह,
58 distance है.
and he has his son of Kutubuddin, has come to depose.
The learned counsel submits that the son of co-tenant,
Yes.
that is the son of Kutubuddin, has come to depose before the court, and it has come on record that there was an eviction suit against him also. It was numbered as 3 of 1991, which ended in a compromise, and ultimately the plaintiff was found to be the landlord.
And he has acknowledged and he has given evidence that all 3 of them were the tenants of.
And he has deposed before the court that all 3 were the tenants under the plaintiff. That's all. हो गया ना last. एक चीज और, क्योंकि जजमेंट दिखाने के लिए जरूरी है, आप ट्रायल कोर्ट का फाइंडिंग्स हमको जरा एकदम एग्जैक्टली कहाँ है वो पैराग्राफ थोड़ा सा बताएं, क्योंकि ट्रायल कोर्ट मोस्ट ऑफ द टाइम आई एम फाइंडिंग वो सबमिशन और फाइंडिंग को सब मिक्स करके लिख देते हैं. There is no segregation. That's a huge problem. At times it is very difficult to segregate. वो अचानक बीच में फाइंडिंग आ जाता है.
जबकि सारा डिस्कशन ऊपर होना चाहिए, फिर अगर ऊपर में
Sequence
कुछ
नहीं।
फाइंडिंग है भी तो एक कंक्लूडिंग एक
या
समरी होना चाहिए.
कुछ अलग से कुछ होता या कुछ बोल्ड होता, उस समय तो ऐसा कुछ नहीं था. You just tell me the findings. पहले तो इश्यूज हम लोग देख लेते कहाँ हैं. issues is in para 4. With page 4, para
हाँ।
6. ठीक है?
ये
हमारे
ऊपर का
इशू कौन सा रेलेवेंट है?
मतलब one to maintainability because
हाँ.
they had said that
One is maintainability. और ये 5.
और 5 is the most important
5. ठीक है?
because 6 admittedly after 1990 they themselves say that they are not paying rent. So once the landlord tenant relationship established, everything else.
और उसके बाद फाइंडिंग बताइए आप.
तो 1, 2, 3 and 4 एक साथ डिस्कशन हो रहा है.
हाँ. ये तो छोटा सा डिस्कशन, इसको जरा पढ़िए.
पूरा ही पढ़ दें.
हाँ पढ़िए. नहीं, ये फाइंडिंग यहाँ पे है ना, प्रस्तुत बाद में. पेज 6 प्रस्तुत बाद.
सेकेंड पेज में जो ऊपर से
हाँ, प्रस्तुत
बाद में वादी के वादग्रस्त परिसर का किराया 50 रुपए महंगाई कहा गया है. इस तरह 12 महीने का किराया 600 रुपए का न्याय शुल्क दिया गया है और यह न्याय शुल्क प्रतिवादी को वादग्रस्त परिसर से निष्पादन के लिए दिया गया है. वादी ने मई 1990, मई फरवरी 1991 तथा 10 महीना का बकाया किराया 500 रुपया वसूली का भी दावा किया है और इस पर भी न्याय शुल्क दिया गया है. इस प्रकार वादी कुल 1100 रुपए का यथा मूल्य न्याय शुल्क दिया गया है. प्रतिवादी का अभिकथन है कि वादग्रस्त परिसर का कीमत 40,000 रुपया है, अतः इस 40,000 रुपये का वादी का मूल्य एवं न्याय शुल्क नहीं देता. यह बात चलने योग्य नहीं है. प्रस्तुत वादग्रस्त संपत्ति से प्रतिवादी को निष्कासन हेतु 500 रुपये का बकाया किराए की वसूली हेतु निर्दिष्ट किया गया है. ऐसी स्थिति में वैधानिक रूप से 12 माह का किराया ही न्याय शुल्क के लिए वादग्रस्त परिसर का कीमत माना जाएगा तथा जिस बकाया राशि की वसूली हेतु वादी ने दावा किया है वह 500 रुपये का, वाद को 1100 रुपये तथा यथा मूल्य न्याय शुल्क लगेगा जो वादी ने दाखिल किया है. ऐसी स्थिति में मैं यह पाता हूँ कि यह इस बिंदु पर प्रतिवादी का लिखित वक्तव्य विधिमान्य है और वादी द्वारा दिया गया न्याय शुल्क पर्याप्त है. ऊपर पर्याप्तों के आधार पर वाद पत्र संख्या 3 को वादी के पक्ष में निर्णय किया गया. हम थोड़ा पास पढ़ेंगे जहाँ रेलेवेंट होगा हम थोड़ा स्लो.
ठीक है, हम पढ़.
प्रस्तुत वादी ने सलेहा खातून नसरुन्निसा सैफुन्निसा के प्रतिनिधि के रूप में वारफटनी के आधार पर दाखिल किया तथा प्रतिवादी को उन 3 महिलाओं ने वादग्रस्त परिसर का किरायादार बताते हुए 2 महीने से अधिक का बकाया किराया के कारण निष्कासन वाद निर्दिष्ट किया है. ऐसी स्थिति में इस बात में कोई पक्ष दोष नहीं दिखाई देता. सुनवाई के दौरान प्रतिवादी ने इस बिंदु पर कोई प्रकाश नहीं डाला कि कैसे इस बात में पक्ष दोष प्रदर्शित है और मैं बताता हूँ कि बात जिस रूप में परीक्षित है पक्ष दोष से प्रदर्शित नहीं है. ऐसी स्थिति में विवाद पक्ष संख्या 4 वादी के पक्ष में निर्णय किया गया. वाद पत्र संख्या 5 वादी द्वारा
ये फाइंडिंग में है, ये बहुत लंबा है, अब इसका फाइंडिंग में
बेटर होगा पिछला पेज से पढ़ें. पैरा 12 पेज 12.
हाँ वहीं से पढ़िए.
हाँ. वादी संख्या 7 सुशील चंद्र झा है. ये भी औपचारिक साक्षी है. उन्होंने 20 प्रपत्र 8 को औपचारिक रूप से प्रमाणित किया. प्रतिवादी ने भी इस बात में एक साक्षी प्रस्तुत किया है. प्रतिवादी संख्या 1 और खुद प्रतिवादी मोहम्मद इब्राहिम मिस्री हैं और इन्होंने साक्षी में बताया कि तकरारी जमीन विशेष संविधान विधि दी थी. सन 1992 में यह जमीन इस शर्त पर इट वुड बी 1962
यस 19
में उन्होंने यह जमीन इस शर्त पर दिया था कि जब तक मैं जिंदा हूँ तकरारी जमीन पर गैरेज बनाकर रहो. इस जमीन पर शेड और कोठरी सन 1962 में बनाया. स्पष्ट लगता है कि 1992 गलती से लिखा गया है. 1962 की जगह इन्होंने 1992 कह दिया है. अपने साक्ष्य में इन्होंने बताया कि सबीरन बीबी मुझसे 200 रुपए सालाना फी लेती थी, जो बाद में बढ़ाकर 500 रुपए सालाना हो गया। सबीरन बीबी 1968 में मर गई, लेकिन उस जमीन और मकान को मैं अभी भी रहता हूँ। 1968 के बाद कनीज फातिमा को फी देता हूँ। कनीज फातिमा सबीरन बीबी की लड़की है। वे 1990 तक लाइसेंस फी दे चुकी है। 1991 का लाइसेंस फी लेने कनीज फातिमा के यहाँ गया था, वह लेने से इनकार किया। अपने साक्ष्य में इन्होंने यह भी कहा है कि वादी को तकरारी जमीन और मकान में कोई हक नहीं है। इस साक्षी ने अपने साक्ष्य में यह स्पष्ट नहीं किया है कि क्यों 1990 तक कनीज फातिमा वार्षिक किराया दिया, पर 1991 से किराया लेना क्यों बंद कर दिया। दिस इज इम्पोर्टेंट। इन्होंने अपने साक्ष्य में यह भी बताया कि 1991 का किराया, वार्षिक किराया लेकर ये कनीज फातिमा के यहाँ गए, पर वह किराया लेने से इनकार कर दिया। इस अपने साक्ष्य में इन्होंने यह नहीं बताया कि उन्होंने क्या कहा और किराया क्यों नहीं लिया। यह तथ्य वादी के अभिकथन को प्रमाणित करता है कि बंटवारा वाद संख्या 3187 में वादग्रस्त परिषद कनीज फातिमा की बहन शोहरा खातून की लड़कियों सलिहा खातून, असफून निसा और खैरून निसा को मिला, और इसी कारण कनीज फातिमा ने 1990 के बाद किराया लेना छोड़ दिया। प्रति परीक्षण में इस प्रतिवादी मोहम्मद इब्राहिम मिस्त्री ने कहा कि लीज जमीन में मकान बनाने के लिए खास महल ऑफिसर से परमिशन लेना पड़ता है। सबीरन बीबी खास महल ऑफिसर से खुद परमिशन लेकर मकान बनाने को दी थी। मकान मालिक का हक सबीरन बीबी को ही रहा। इनके इस वक्तव्य से स्पष्ट जाहिर होता है कि अपने को सबीरन बीबी का किराएदार स्वीकार करते हैं, क्योंकि यह पूर्णतः मकान मालिक का हक सबीरन बीबी को ही था तथा सबीरन बीबी की पुत्री शोहरा खातून की लड़कियों, सबीरन बीबी की दूसरी पुत्री कनीज फातिमा के बीच उप बंटवारे के मुकदमे में वापस शोहरा खातून की लड़कियों को मिला। ऐसी स्थिति में निश्चित रूप से प्रतिवादी मोहम्मद इब्राहिम मिस्त्री वादी के किराएदार समझे जाएंगे। प्रतिवादी के तरफ से तथाकथित वार्षिक लीज का कोई कागजी सबूत प्रस्तुत नहीं किया गया, न ही ऐसा कोई साक्ष्य दिया गया है जिससे प्रतिवादी के उपयुक्त वक्तव्य की संतुष्टि हो। इस बिंदु पर प्रतिवादी का साक्ष्य में विश्वास योग्य नहीं पाता हूँ। मैं यह पाता हूँ कि प्रतिवादी इब्राहिम मिस्त्री सलिहा खातून, असफून निसा, खैरून निसा के किराएदार की हैसियत से वादग्रस्त संपत्ति में रह रहे हैं तथा मतलूब आलम सहलिया खातून, असफून निसा एवं खैरून निसा की किराएदार प्रतिनिधि पार्टी के आधार पर प्रतिवादी के हैसियत से प्रतिनिधि के हैसियत से ही वाद को प्रस्तुत वाद प्रतिवादी के विरुद्ध निर्देश किया है। ऐसी स्थिति में मैं यह पाता हूँ कि विनिश्चित रूप से उभय पक्षों के बीच वादग्रस्त अनुसूचित ए में दिए गए परिसर के लिए मकान मालिक और किराएदार की रिश्ता है, और ऐसी स्थिति में यह वाद पद संख्या 5 वादी के पक्ष में निर्णित किया गया।
तो again the findings ट्राई कोर्ट का अपील कोर्ट
6 देख रहे हैं। ठीक है, 6 इज डिफॉल्टर उठो appellate
एक सेकंड। appellate कोर्ट
हाँ, appellate court का इशू उसके बाद हम all arguments have been noted after the quoting of issues in page number 6. Argument of the parties have been. But actual finding starts from page 16. para 18. Shall I read?
नहीं आपको हम खाली दो चीज खोज रहे हैं. What is the finding regarding partition and the compromise? What is the finding? You see, there is a dispute. They have decided. They have said that there is no partition suit, no compromise. But is there any finding by the court that there was a partition and this property was allocated to these three persons?
By the trial court.
By the
first appellate.
By the trial court, we have seen this.
Yes.
आप जब देखिए, is it a finding or it is something else?
नहीं वो fraud.
You just have a look at this.
Yes. The trial court has presumed
No,
on
not
their
presumed.
statement.
No.
Yes. That finding by presumption.
No, whatever
It is a finding by presumption.
But there is a finding.
Yes. Presumption
There-
that there was a partition suit
No,
and without
as a finding by
producing the
whatever
judgment
be
and
the
degree.
nature of finding,
Lordship.
but there is a finding by learned trial court.
That we have just seen. Lordship.
Yes, we have seen
हाँ.
that there is a finding that there was a partition and the property was allocated to the three sisters.
That
There
is
is
what-
a finding.
वही तो उसूल कह रहे हैं. ये जो finding है presumption पे है. Without any
नहीं है.
document on record. Yes.
That's it. Whatever it is, but there is a
That is a
finding.
finding.
That-
Against that, the appellate court has reversed that finding.
I just want to know where is that reversal that there was no such partition. There has to be a reversal.
इसको तो हम पैराग्राफ 7 से पढ़ेंगे.
आपको आपको पढ़ना है क्योंकि appellate court आप डिफेंड कर रहे हैं. आप बताइए.
क्योंकि I could not get that finding.
फाइंडिंग आपको कैसे नहीं मिला?
नहीं वो वाला जो appellate court जो
आपको एक सेकेंड.
appellate court
ये फाइंडिंग है. ट्रायल कोर्ट का फाइंडिंग है.
ट्रायल कोर्ट में है.
ट्रायल कोर्ट में फाइंडिंग है.
रिवर्सल नहीं है वो.
हाँ, ट्रायल कोर्ट में ये भी फाइंडिंग है that there was a partition and this property was
पैराग्राफ
allocated
18 में उसूल दिया हुआ है. पैराग्राफ 18 में पढ़ा जाना वही.
of the appellate court.
हाँ.
appellate court बताइए.
पैराग्राफ
कोई
18
फाइंडिंग
पढ़ी ना पूरा उसी में आ जाएगा. यही पे तो है 87 के बारे में.
पैरा 18 दिखाइए. Where is para 18?
Page 16.
पढ़िए. If there is a reversal of finding तब फिर आपका केस कैसे बनेगा? पढ़िए. पैरा 18. पढ़िए.
After hearing the argument of both the parties in this case and on careful scrutiny of the evidence on record, in this case I find that admittedly there is no agreement of tenancy or kirayanama neither in between the appellant defendant and as such the respondent plaintiff in this case, nor there was any such documentary evidence showing the existence of the tenancy between the appellant defendant and predecessor in interest of the plaintiff, Anish Patma or Sabiran Devi. There is no any documentary evidence like rent receipt to show that the appellant defendant was paying any rent of the tenanted premises either to Sabiran Bibi or to Khaniz Fatima. Then the owner of the suit premises through when the Saliha Khatun and others have acquired the suit holding
Yes.
on the basis of compromise decree passed as
As
claimed.
claimed.
In
Nothing is
this
there and
case,
therefore.
Just
in this case, I also find that the plaintiff respondent have not examined the said Khaniz Fatima as witness on their behalf to support that defendant appellant was a tenant under her or there was any relationship of landlord and tenant in between her and the defendant or that the defendant was paying monthly rent to her and not the license fee as claimed by the defendant. No explanation has been given by the plaintiff in the said suit as to why Khaniz Fatima or her husband was said to be realizing the rent from the alleged tenant of the suit holding on basis of Khaniz Fatima were not examined in the said suit, though they were related to them. In this case, I further find that the plaintiff respondent has only based his case on the basis of Exhibit 5 series with a counterpoint of the rent receipt said to have been paid by the appellant defendant to the plaintiff from 1 to December 1989 to April 1990 at the rate of 50 per month. But in this case, I find that the said counterpoint of the rent receipt does not bear the signature of so and so and so and so. And then I'm skipping few lines here, last 7 lines, then again the finding is there. I also find on the fact and circumstances of the case that the said Exhibit 5 series rent receipt cannot be relied upon to be conclusive proof to show relationship of landlord and tenant between both the parties or that the defendant was paying the monthly rent of the suit premises to the plaintiff responding, the possibility of manufacturing of such counterfoil rent receipt cannot be ruled out. The learned lawyer for the respondent has taken a plea in his that the defendant did not sign the counterfoil, or their all these are in the finding of counterfoils. This shall I read entire?
No, we have seen.
Has taken a plea
Exhibit
in his
5
argument
series
that
has
the
been
defendant-
rejected. Then he discusses the oral evidence in para number 21.
Now remains the only oral evidence, that is oath against oath adduced on behalf of both the parties on the point of relationship of landlord and tenant between the plaintiff and the defendant. In this case, the learned lawyer for the respondent has taken a plea that the defendant has himself claimed to be a licensee in respect of the suit premises previously under Sabiran Bibi and subsequently under Khamis Fatima, and he was paying only license fee to them, previously rupees 200 per year and subsequently as rupees 500 per year, but the defendant has not filed any sheet of paper to show that he was occupying the tenanted premises as a licensee, not as a tenant. The defendant has also admitted that the owner of the suit holding was Khamis Fatima, and as such the defendant was a tenant under Khamis Fatima, and subsequently when Saleha and others stepped into the shoes of Khamis Fatima and became the owner in respect of the suit property, the defendant is also presumed to become a tenant under the plaintiff, and there is also a presumption of atonement by the defendant. But I am not inclined to agree with such submission of the learned lawyer for the defendant. It is true that the applicant defendant has not filed any documentary evidence in this case that he was holding the tenanted premises as a licensee under Khamis Fatima, or he was paying any license fee to her. But the case of the plaintiff and the defendant stand on same footing that both of them have got no documentary evidence to substantiate the claim as licensee vis-a-vis tenancy. But in the present case, I find that the liability of the plaintiff respondent is greater to establish that there was a relationship of landlord and tenant between both the parties, and the defendant was paying rent of the suit premises. But as stated above, in this case, I find that the plaintiff respondent has failed to establish that the defendant applicant was a tenant in the suit premises under him or under the predecessor in interest of the plaintiff by reliable evidences. Even if the defendant has not been able to show that he was holding the suit premises as a licensee under Khamis Fatima, but the defect in the plea of the defendant cannot be a ground for the plaintiff to evict the defendant from the suit premises under the PBC Act, as the plaintiff has failed to establish landlord relationship of landlord and tenant in between both the parties in this suit. In this case, I also find in the case law refers to so that
You see, even the atonement has not been proved.
yes, that is the
So if the atonement is not proved,
One more thing is Lordship, the notice is
atonement
required to
is
be
not
given.
required.
the atonement is not required, but how will a person become a defaulter? In absence of atonement.
Prior to atonement, Lordship, a notice is required to be given. Since by this compromise petition, I have become the owner of the land.
We have given
In
notice.
absence of atonement, how will he start paying rent to the person who has acquired the property? Atonement is absent.
Atonement is not required, it is
Atonement is not required, but the point is, the fact that a person has acquired the property is something which has to be brought to the knowledge of the tenant.
that we have brought it to the
When?
notice by way of notice.
No, it was never served.
Never served.
That was never served.
But even otherwise, Your Lordship,
I
even
know,
otherwise,
that is the
by way
finding
of
of fact.
oral evidences, there were two other oral evidences. One was the own the son of the Kutubuddin, who was another tenant, another witness who has come to prove and default also. He is
Where
the
is the discussion
he
of
is
that?
the dever of.
Where is the discussion of that evidence? He was PW?
He was PW.
Court
And
says
where is
Lordship,
the discussion of that?
He is
Not
the
binding upon the
own
plaintiff since he was a
brother-in-law of the Kanishka.
Where is the discussion of his evidence?
His evidence is discussed by the trial court.
An appellate court?
Appellate court, it has not taken into account that.
PW? He is PW?
PW.
appellate court लिया है हमारे डिस्कशन में राइट टू पैराग्राफ
PW करता है कौन? और उसका डिस्कशन करता है. PW?
PW.
Where is the discussion of PW?
इसमें
पैराग्राफ लॉर्डशिप
ट्रायल
पैराग्राफ
कोर्ट भी और appellate court भी.
appellate court का पैराग्राफ 10 में देखा जाए उसको
Appellate court para 10.
पैराग्राफ इसमें eviction suit 3 of 91 has been discussed in the last line of paragraph 10 देखा उसको ऊपर से पढ़ लेंगे
PW2 दिखाइए. Where is the mention of PW2?
ये
Yes.
eviction suit की बात
It
कर
is
रहे हैं
argued that even if father of PW2 was, PW2 has stated. No, ये तो सिर्फ argument चल रहा है. Where is the finding?
argument है
Argument है. Where is the finding? Referring to PW2 and discarding his evidence. होना चाहिए ना उनका एविडेंस. ठीक है, मान लेते हैं. ओरल एविडेंस में जो इन्होंने डिस्कस किया है पैरा 21 में, इज देयर एनी डिस्कशन ऑफ PW2?
किसमें?
पैरा 21 now remains only the oral evidence, that is oath against oath is to be discussed. Is there any discussion of PW2?
पैरा 21 में तो नहीं है, उनके नीचे में देखो. PW2 is not there. PW4 का है, who's the plaintiff?
PW4 का है. PW2
इन पैरा 21 नहीं है बट वो पैरा 10 में ही आया है जो सूत्र नहीं है तो
सबमिशन
सबमिशन है व्हाटएवर इट इज
अटॉर्नमेंट का फाइंडिंग ट्रायल कोर्ट में कहाँ है?
गवर्नमेंट का कोई एविडेंस ही नहीं है कहां से फाइंडिंग है
ये अटॉर्नमेंट का एविडेंस नहीं है, मतलब अटॉर्नमेंट का प्ली तो है ना. देयर इज अ प्ली ऑफ अटॉर्नमेंट.
हाँ ये कहते हैं कि 50 रुपए का दिए वो 5 रेंट रिसिप्ट दिखाया काउंटरफॉल था दैट हैज बीन दैट इज द ओनली अटॉर्नमेंट
नहीं नहीं ऐसा नहीं.
नहीं हम जो रेंट रिसिप्ट देंगे उसको वही दैट इज द अटॉर्नमेंट अदरवाइज देयर इज नो अटॉर्नमेंट हम तो कह रहे हैं कि आई डोंट नो हिम
You see, there are 3 tenants in the premises. One of them has deposed before the court, right? By saying that he has been paying rent and there was a rent suit and ultimately which ended in a compromise. Now the point is, okay, अपना कहानी जो वो सुनाया, did he say in evidence that all the 3 persons used to pay rent to them?
हाँ वो तो हम लोग का एविडेंस में है.
Evidence में finding discussion कहाँ?
नहीं है फाइंडिंग.
Trial court में नहीं है.
Appellate में नहीं.
Trial court?
ट्रायल कोर्ट है.
ये टॉर्नामेंट ऐसा होता है हुजूर कि हम इनके साथ गए थे यहाँ जाके देखे ये हमारे सामने रेंट दिए हमसे रेंट लिए दैट इज द प्रॉपर वे ऑफ टॉर्नामेंट इफ समवन सेज दैट इफ समवन सेज इन हिज केस दैट आई वाज द टेनेंट एंड आई हैव कॉम्प्रोमाइज्ड आई हैव वेकेटेड द प्रीमाइसेस दैट कैन नॉट बी बाइंडिंग इन फॉर
No, that is, you see, if he has vacated the premises and he has been paying the rent by virtue of a compromise, it is immaterial.
That
will not bind on you.
Yes.
But if he has given a statement that all the 3 tenants used to acknowledge them as tenant and used to pay rent, that is a different evidence altogether. That is not an evidence on compromise. He is a co-tenant in the premises and he is giving an evidence that all the 3 persons after the compromise used to pay rent to this particular person. So I just want to see that
उसका एविडेंस में
evidence कहाँ है इसका?
हाँ
वो लिखा नहीं डिपोजिशन में
ये पढ़िए तो पैरा 10 में साक्षी संख्या 2,
अपने
ये जो
ट्रायल
वादी संख्या
ट्रायल
2,
कोर्ट का पेज
ट्रायल
10
कोर्ट का पेज 10 में पढ़िए इसको। सरफराज।
ये सरफराज ही इज दी फर्स्ट सन ऑफ कुतुबुद्दीन।
यस यस, यही एक टेनेंट
नहीं
एग्जामिन हुआ
नहीं,
है।
एक टेनेंट वो है और एक कनीज फातिमा का देवर है वो हमको
देवर भी टेनेंट है।
नहीं, देवर टेनेंट नहीं है, बट बिकॉज ही वाज रिलेटेड टू कनीज फातिमा itself, to whom the property entire dispute is with regard. So he is related to Kaniz Fatma, who is saying that I am the land.
रिलेटेड नहीं, आप ये टेनेंट वाला।
हाँ, अब ये दिखा पढ़ दे रहे इसको। वादी संख्या साक्षी संख्या 2 मोहम्मद सरफराज है। इन्होंने भी अपने साक्ष्य में इस बात की संतुष्टि किया है कि प्रतिवादी वाद 10% के किराएदार हैं और किराया वाले हिस्से में एक टीन शेड है तथा पक्की जमीन है और इनमें पहले गैरेज था, अभी बालू बेचते हैं। अपने साक्ष्य में इन्होंने यह भी बताया कि मेरे पिताजी भी पहले किराएदार थे और 50 रुपए महीना देते थे, लेकिन हम लोगों ने अभी खाली कर दिया। इनके पिताजी कुतुबुद्दीन भी वादग्रस्त मकान के किराएदार थे। इस तथ्य को ये स्वीकार किए हैं और स्वीकार किए हैं कि इन लोगों ने इस अंश जिनमें ये लोग किराएदार पर थे खाली कर दिया। इस संदर्भ में वादी के तरफ से प्रदर्श 9 और 10 प्रस्तुत किया गया है। तो निष्कासनवाद संख्या 3 सन 91 में दिनांक इतना इतना के आदेश पत्र की सच्ची प्रतिलिपि प्रमाणित प्रतिलिपि और उसी बाद में बिक्री की सच्ची प्रमाणित प्रतिलिपि है, जिससे जाहिर होता है कि मतलूब आलम ने ही उक्त निष्कासनवाद संख्या सन 3 1991 मोहम्मद कुतुबुद्दीन पर दाखिल किया था, जिसमें 1593 के संधि के आधार पर वाद का निष्पादन हुआ और कुतुबुद्दीन ने तकरारी मकान खाली कर दिया। प्रस्तुत वाद के वाद पत्र में वादी द्वारा कहा गया है कि चाईबासा खास महल में कुल 3 किराएदार थे। उन 3 किराएदारों में एक कुतुबुद्दीन को भी कहा गया है और कुतुबुद्दीन के लड़के ने वादी साक्षी संख्या 2 के रूप में आकर उक्त तथ्य को स्वीकार किया है तथा प्रदर्श 9 और 10 से भी जाहिर होता है कि कुतुबुद्दीन निष्कासनवाद संख्या 91 में दिनांक इतना इतना कुछ संधि के आधार पर मकान खाली कर दिया। इन तथ्यों से यह प्रमाणित
तो
होता है
फाइंडिंग आ गया
कि बंटवारा वाद संख्या इतना के आधार पर चाईबासा खास महल सोइंसो में अशरफुल निसा और खैरुल निसा के स्वतः वाद में कब्जा हुआ और इन लोगों ने अपने प्रतिनिधि तो आलम के मार्फत निष्कासनवाद संख्या 3 सन 91 मुंसिफ न्यायालय के न्यायालय में दाखिल किया और एक किराएदार मोहम्मद कुतुबुद्दीन को निष्कासित किया। उसी परिषद के दूसरे किराएदार प्रस्तुत वाद के प्रतिवादी इब्राहिम मिस्त्री हैं। वादी के साक्षी संख्या 3 रास बिहारी मिश्रा है। ये औपचारिक ये औपचारिक है, इसलिए इसको
ये कहीं डिपोजिशन में नहीं आया है कि ये लोग सब किराया देते थे, हम भी किराया, वो अपने बारे में बोला है।
ठीक हो गया आपका।
हाँ, हम एक बार एविडेंस ही डायरेक्ट पर
PW2
हाँ,
पढ़ी
जो नहीं नोट किया है ना, एविडेंस डायरेक्ट हम पर हम लोग तीनों के बारे में
and I think this should be the last one.
yes last one. You know, here the handwritten that handwriting is very bad.
PW2 पढ़ी
इब्राहिम मिस्त्री, दोनों पक्षों में जानता हूँ। इब्राहिम मिस्त्री बड़ी बाजार में वार्ड नंबर 13 में किराएदार की हैसियत से मकान में रहते हैं। प्रतिवादी का किराया वाला हिस्सा वह टीन शेड है तो और पक्की जमीन है। पहले टीन का गैरेज था, अभी बालू बेचते हैं। वादी का किराएदार मेरे पिताजी भी थे। मेरे पिताजी गनीज फातिमा के किराएदार थे। उनके पूरक प्रतिवादी रहता है। वादी का किराएदार 3 किराएदार था। मेरे पिताजी इब्राहिम और नारायण साहब। वादी ने हम लोगों के विरुद्ध मुकदमा किया था। हम लोगों ने खाली कर दिया है। 50 रुपए महीना किराएदार थे। तीनों 50 रुपए देते थे। तीनों 50 रुपए देते थे।
आगे बढ़िए।
With objection, this was there. Then cross examination. मेरे पिताजी जिस भाग में किराएदार थे उसका होल्डिंग नंबर प्लॉट नंबर नहीं जानता हूँ, चौहदी जानता हूँ। उत्तर कनीज फातिमा एंड बाउंड्री दिया हुआ है। उत्तर और दक्षिण कनीज फातिमा है, एक तरफ वादी है, ये सब डिस्क्रिप्शन। देन मेरे पिताजी के विरुद्ध जो मुकदमा हुआ था वो मुंसिफ के यहाँ था। वाद संख्या 390, इस वुड बी 390 था। गवाही में नहीं था। मुकदमा में सुलह हो गया है। Then defer. Then para 6. तकरारी मकान का कागज नहीं देखा है। केस म्युनिसिपल खतियान नहीं देखा है। पूरे प्लॉट पर 20-25 मकान और दुकान है। कौन आदमी किस हैसियत से रहते हैं उसका कागज नहीं देखा है। वे लोग किराएदार की हैसियत से ही रहते हैं। चूंकि मैं भी किराएदार था। मैं पहले गनीश फातिमा का किराएदार था, बाद में सलेहा खातून थी। किरायानामा का एग्रीमेंट नहीं था। मैं गनीश फातिमा का किराएदार 1966 से था। स्वतः मेरे पिताजी 1989 तक मेरे पिताजी किराएदार थे। मेरे पिताजी जीवित थे। मेरे पिताजी के साथ किराएदारी का एग्रीमेंट नहीं था। गनीश फातिमा का किराया का रसीद घर में होगा, वो दाखिल करूंगा। सलेहा खातून का किराएदारी का एग्रीमेंट या रसीद मेरे पिताजी के पास है या नहीं मालूम नहीं। मेरे पिताजी जो किराया का मुकदमा था उसका नंबर 391 था। उस मुकदमा में मैं और मतलूब ने सुलह किया था। सुलह का तारीख महीना साल याद नहीं है। मैं गवाही नहीं दिया था। किसका गवाही हुआ था मालूम नहीं। इब्राहिम मिस्त्री किराएदार की हैसियत से रहते हैं। इसका कागज नहीं देखा है। रसीद किराया का नहीं देखे हैं। गनीश फातिमा या सलेहा खातून को स्वयं किराया वसूलने नहीं देखा। इस मुकदमा की जानकारी मुझे कब हुई मालूम नहीं। आज से 15 दिन पहले मालूम हुआ कि गवाही देना है। दादी ने कहा था कि गवाही देने। मैंने सुलह कर लिया है, इसलिए अभी गवाही दे दिए। बात पत्र की निजी जानकारी नहीं है। यह मुकदमा मकबूल ने किया है। मकबूल आलम ने कहा था कि मकान बनाकर एक कमरा दुकान दे देंगे, इसलिए सुलह किया था। नारायण साहब सुना कि मर गए। करीब 2 वर्ष पहले मरे। उनका किराया का कागज नहीं देखा। ऐसी बात नहीं है कि इब्राहिम मिस्त्री वादी का किराएदार नहीं है। ऐसी बात नहीं है कि वादी की This is my last submission would be that the entire fact would go to show that lastly my statement in the plaint was that this property has been allotted to me in a partition suit and which was not specifically denied. And then the defendant himself says in his evidence that Kanish Fatima, taking shelter of that, she refused to accept it. Thank you.
Buddha, sir, I am not well. धीरे धीरे करें. First of all, Lordship, I will take my lord to the plaint. How the plaint itself is not maintained. For that, Lordship, I will give some judgments also. As per the plaintiff, from the first line itself, the plaintiff is the constituted attorney of Saleha Khatun such and such, or president of such and such. since 31/1980. Lordship has taken note of that. 1980 power of attorney was executed. Admittedly, at that time, this property did not belong to the three ladies, Lordship. And therefore, the power of attorney at that time will only confine the period when the power of attorney was granted. Subsequent property which was acquired admittedly, if acquired, this property will not devolve upon the person who was holding the power of attorney unless and until that power of attorney is rectified, ratified, or a fresh power of attorney is given. On that date, only the persons who are having the property that can only be stated in the power of attorney.
The power of attorney was specifically mentioned in this property.
Lordship, the entire thing has been mentioned. It cannot say by future properties which, if acquired by me, that will also be governed by this power of attorney. No power of attorney can be stated, and that will be illegal in the eye of law.
In the year 1980,
Lordship.
after the death of the original allottee, she died in 65 or so.
68, and thereafter
She died in 68.
68.
And then
A
there
fresh
was-
lease was given
yeah, in
to
85.
Lordship, in 85.
85. In the meantime, 1980,
Yeah,
there was a power of attorney.
power of attorney.
Correct? So by virtue, so therefore, both the daughters of the original allottee were the co-owners of the property
At that time.
at that point of time.
At that
Right?
time.
And now this power of attorney was executed by the three daughters
Three daughters.
of one of the daughters.
all the three
right.
daughters. Yes.
All the three daughters
नहीं,
of one of the daughters.
ये कनीज फातिमा के तीनों बेटी.
नहीं,
Sorry. सलेहा की. हाँ.
कनीज के नहीं.
Kaniz was the Mausi. Sohra and Kaniz was two sisters. हम समझ
तो
गया.
सोहरा के तीनों बच्चों ने ये वाली किया है. And this power of attorney was collecting rent.
Correct.
Yes.
Then for other things also.
For other things also.
Yes.
Right? And ultimately, okay, right, then,
हाँ. अब ये हो गया. This is the first. Now Lordship, the plaint has been filed.
so what do you want to derive out of it?
Yes, हम अपने WS उसमें आ रहे हैं. Because specifically we have taken paragraph 2 and 3 that since the person who has filed the power of attorney, who has filed this case, was the power of attorney holder. And Lordship, we have not seen till date that a person directly being the power of attorney institutes a suit without impeding the original owners of the suit. Admittedly, Lordship, he was not landowner. The landowners were not made party, although through.
See, is it within the scope of the point of law?
Yes.
Which has been framed?
Yes,
Which
because
point of law?
landlord and tenant relationship.
No, which point of
Yes,
law?
that is-
That the suit was not maintainable. Landlord-tenant relationship is something else.
हाँ,
But the suit was not maintainable.
not maintainable. Yes.
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 Is it within the contours
हाँ.
of the substantial question of law? You are referring to which substantial question of law?
निकाल. Then the substantial question.
And whether the learned first appellate, you see, the learned trial court holds that the suit was maintainable. Does the learned appellate court holds that the suit was not maintainable on this ground? The appellate court does not hold that it is not maintainable on this ground. Then how do you include it in any of
हम
this?
उसको कह रहे हैं.
देखिए ऐसा आप सब्सटेंशियल कौन सा सब्सटेंशियल क्वेश्चन ऑफ लॉ में ये पावर ऑफ अटॉर्नी
Second देखा जाए. Whether learned lower appellate court has
हाँ.
committed error of law
हाँ.
in holding that defendant could not substantiate its case that the plaintiff is licensee or not.
that the defendant is licensed.
Defendant is licensee.
ये तो whether the defendant is licensee or not is the question of law.
Yes.
इसमें ये power of attorney holder जो है
हाँ.
ये the suit was not maintainable at his instance ये point इसमें कैसे आप cover करेंगे?
Secondly, Lordship, the first one.
First
whether
one
the
भी देख लीजिए.
committed serious error of law
Yes.
in reversing the judgment and degree of the learned trial court.
But the appellate court has not reversed the judgment on this ground. There is a concurrent finding that the suit was maintainable.
Appellate court maintained पे नहीं गया है सर.
गया या नहीं गया है? इस finding को reverse तो नहीं किया है ना? तो फिर आप इसको कैसे बहस करेंगे?
But Lordship, at least.
देखिए ये इतना writ petition मत बनाइए।
हाँ,
आप
हमने
बताइए कि आपका ये plea that the power of attorney could not have maintained a suit. You remember the very first day I scolded him also.
Yes,
कैसे
yes.
चलेगा?
हाँ.
लेकिन वो हमारे substantial question of law में नहीं है।
हमको उसूल बनाने
नहीं है वो हम नहीं डिसाइड करें, हम आपके इस चीज को बहुत अप्रिशिएट कर रहे हैं।
Lordship
But
is
the
so
point is-
नहीं, the lordship at the time of hearing also.
नहीं
If
अभी नहीं,
lordship-
प्लीज 3 दिन सुनने के बाद
नहीं, हम नहीं कर रहे, हम उसूल बनाए हुए हैं चूंकि हम कल फाइल नहीं कर पाए,
ठीक
हम इसको बनाए
कोई
हुए
बात
हैं,
नहीं,
इसलिए नहीं फाइल कर पाए चूंकि
ठीक
आज ही
है,
का
आप
रखा
बहस
हुआ है।
करिए, लेकिन it is my, I am just opening myself that this does not come in
नहीं,
within any of the
But
substantial
if
question of
anything
law.
is anything is
Please.
glaring on record,
नहीं, it is not.
For
so,
that
it is
lordship
not
the-
so glaring. It is not so glaring.
a person who is इसमें हुजूर इतना तो हम बस हम एक ही तब सबमिशन करेंगे इसमें।
हाँ ठीक है।
हम दो जजमेंट को जो रिलाई करते हैं ये जजमेंट को देते हैं
Yes.
दे दिए ना
Yeah.
2005 वॉल्यूम 2 SCC
2005 volume 2 SCC.
हाँ वेरी लॉर्डशिप
Para number please.
Wherever उसको हम रिकॉर्ड नहीं कर पाए। The summary of this is that if the power of attorney holder or the principal does not come and depose in the witness box, the plaint cannot be affirmed. These judgments of the Supreme Court, two judgments lordship, 2005 volume 2 and 13 volume 2. ये इस पे हो गया उसको और
नहीं ऐसे नहीं, आप हमको बताइए, क्योंकि हम लोग तो अभी तक ये जानते हैं that power of attorney holder can depose
the special knowledge of the principal cannot be deposed by the power of attorney.
कौन सा स्पेशल नॉलेज की बात है?
स्पेशल नॉलेज ये है कि पार्टीशन हुआ, जजमेंट डिग्री ये फाइल नहीं किए हैं, the persons are not before that court, even the original owners, three sisters, not to talk about the Kanis Fatima, even these three sisters, एक तो अभी भी alive हैं, they have not come and deposed before the court. How it will be derived that there is a transfer of property, chain of circumstance is there. भाई ओनर होगा, if I am accepting that he is the owner, then I am out of the court.
Personal knowledge of power of attorney.
Personal knowledge of the principal cannot be deposed by the power of attorney. This is the principal
Para
lordship in
number
these two
बताइए,
judgments. सारा हम बता देंगे, हम एक ही पॉइंट को देखते हैं।
आप देख के बताइए।
सारा 12 पे बताया से and my second limb of argument is
इसके लिए आप दो जजमेंट दिए हैं,
हाँ।
2005 2 SCC 217, another one
13-12 page 64. And the most important lordship three judgments I am citing again. उसका हम पैरा दे दिए हैं, उसको हम ध्यान करें. What I have just stated, the derivative title of the landlord is required to be seen by the court. If there is a challenge of by the defendant that we have not atoned him as a landlord, neither we are accepting the title. First lordship is 2017 volume 2 SCC. Para 24 and 25. शायद उसमें पैराग्राफ लिखा हुआ होगा। Not sure.
बताइए।
अच्छा। The law relating to derivative title to landlord, lessor, and challenge if made to such title by the tenant lessee during the subsistence of the tenancy in relation to the demise property is fairly well settled. Though by virtue of section 116 of the Evidence Act 1872, the tenant is stopped from challenging the title of his landlord during the continuance of a tenancy, yet the tenant lessee is entitled to challenge the derivative title of the assignee vendee of the original landlord, lessor, of the demise property in an action brought by the assignee vendee against the tenant for eviction from the demise property under the rent clause. This right of tenant is, however, subject to one caveat, what Lordship was saying, that the tenant lessee is not atoned to the assignee vendee. In other words, if the tenant lessee pays rent to the assignee vendee of the tenanted property, then it results in creation of an attornment between the parties, which in turn derives the tenant lessee to challenge the derivative title of the assignee vendee in this proceeding. However, Once the assignee vendee proves his title to the demised property, the original tenancy devolves to the assignee vendee and the tenant has to pay. Now, Lordship, my submission is only on that ground that till Khanis Fatima everything is okay. But after Khanis Fatima, as we have seen in the print, that the only compromise application has been filed in this suit. Are we supposed to bring the judgment and decree? It is upon them to prove their case. They have to rise and fall on their own pleading and on their own document. Specifically, Lordship, in our WS, which was skipped by my learned friend, I'll just be submitting that we have taken a specific stand that no judgment and decree has been filed. And we have also taken a precaution that even if during the trial, even if it is filed, then also we were not party to the suit. That may be a different thing. But we have taken a specific plea that defendant and the plaintiff has not brought the judgment and decree. Only by way of this partition, this agreement, this compromise petition, it cannot be presumed by any stretch of imagination that the title devolves. Title of a property is a very big thing, Lordship. It is not a small thing that by a simple sheet of paper says that he has signed, he has signed, he has signed, and therefore the property devolves. What about the other co-sharers? It is a compromise petition in a partition suit. It has also not been referred by them that how many parties were there, how many sharers are there. All the sharers have signed, and this is the petition. बस उसे पानी पी ले, difficult बस हो रहा है. I'm sorry, Lordship. And moreover, the Khanis Fatima, who is the person who has given the property as per them, has never deposed before the court, although she was alive. Secondly, all these three daughters, they have also not come before the court. They are the landlords. Even if a Matlub Alam is pursuing the case on their behalf, she should have come. Any one of them could have come. No one came. Even the mother did not come. She is still alive. Oh, sorry, she is now dead. At that time, she was alive. Therefore, the adverse inference, because the right title and interest of a property is being devolved, is to be drawn by the court. And those things have been carefully taken very care of by the learned single judge, division bench. Sorry, the appellate court. आज तबीयत ठीक नहीं है. पहली बार लगता है कि बीपी हमको फर्स्ट टाइम आई एम एक्सपीरियंसिंग, अभी तक हुआ नहीं था.
बीपी हो गया.
हमको लग रहा है ऐसा.
आप जाके चेक करें.
हाँ, हमको लग रहा है बिकॉज बैठ रहे हैं तो
सीधे चल जाइए.
हाँ, खड़े हो रहे हैं तो चक्कर आ रहा है एंड देयरफॉर
खड़े हो रहे हैं, चक्कर आ रहा है तो लो बीपी.
बड़ा बढ़िया से खाना खा के तो आए.
खाना खाने का
झगड़ा होने से नहीं मिलता तो राजी की बात.
खड़े होने से चक्कर आ रहा है तो तीन चीज है, लो बीपी है, बी कॉम्प्लेक्स लो है, या नींद ठीक से नहीं हुआ.
ये नींद हाँ थोड़ा सा डिस्टर्ब था. That may be a cause. Therefore, all these things were appropriately taken care of by the appellate court. And when these persons are not coming, they are the owner of the property. They should have come and deposed. Why they are shying away from the court? Even Khanis Fatima, her husband, both were alive, and this was taken care of by the learned appellate court. The appellate court did not take note that these persons have also not come. We have analyzed 7 witnesses have been examined by them. All these three ladies did not come to them. Now, I should not say the present situation is खाली argument की कह रहे हैं. The entire property has gone to some other person. What fruit they will get? Even the degree if is given, it cannot be executed. Execution होगा तो there will many other litigations will flow from this. Take just for the sake of argument. Now this is the second lordship. One more judgment lordship on this point. 2018 volume 6.
Yes.
ये भी वही है उसमें. Paragraph 42. Same thing. Everything same. Derivative title has to be shown by them. If the title is not shown by the plaintiff, then lordship, no decree or no judgment can be passed in their favor. And this chain is completely missing in this case. And the argument which was made that third person has come and said that all these persons were tenant. In cross-examination, he says Several other persons are there. I have not read Lordship, but I have just heard what they have read. Several other persons are there. In what capacity they are occupying the premises, I don't know.
That's true.
Secondly, he has an interest कि वो compromise इसलिए किया because उसको कुछ मिलना था, घर बना के देना था, and he has admitted that he has a personal interest, and therefore he is coming and deposing in their favor.
So you want to say that in absence of the decree, it cannot be said that this property was allotted.
Devolved
When
upon me.
There is a specific lease deed in favor of
Kanis Fatima.
Kanis Fatima. Now, since it did not, and their entire case is that it devolved upon them.
Devolved.
That is their entire
That
case.
is the case. वहीं से वो टाइटल डिराइव कर रहे
वहीं
हैं.
से वो
टाइटल
title
डिराइव
derive
करेंगे तब लैंडलॉर्ड बनेंगे तब इविक्शन सूट फाइल करेंगे.
हाँ. तो basically वो मतलब this has not been proved.
Yes, all the three judgments Lordship have been not referring, but
And
all the
apart from that, according to you, there is nothing on record to show that after this transfer,
there was
they
atonement.
acknowledged.
Yes,
At least they acknowledged. You see, the point is, it
Yes,
is not,
उसमें तीन
atonement
चीज़ें-
is not necessary.
हुजूर,
Acknowledgement is at
अच्छा
least
अच्छा याद करा
necessary.
दिया. उसमें भी तीन चीजें होगी. Flow of title is required. पहला. दूसरा, after the flow of title, the notice is required, which is also absent. And thirdly, my atonement is required.
The atonement is not required. But the point
If
is,
title is proved,
yes.
if title comes, तो हमको atone करें चाहे नहीं करें, वो आके बोल भी देगा, then also that is acknowledged.
हाँ. मतलब लेकिन आपको एक information
हाँ.
और आपका एक
Flow of
act,
title. Yes.
your act that you acknowledge,
Yes. Any kind of act.
हाँ. कम से कम एक notice भी होता
Yes.
कि that you pay me the rent because
Yes.
I am the new
Yes,
landlord.
yes.
That would have been sufficient.
Sufficient.
But even that is not there.
That is not.
And no reason has come up as to why Kanis Fatima refused to accept it. That has not come up.
Yes. हम उसका हम रिप्लाई में दिए हैं, उसमें लिख दिए हैं. It can be for many reasons. N number of reasons. किराया बढ़ाना चाहती थी, हमसे अभी झगड़ा हो गया था, नहीं लेना चाहती थी, और किसी को देना चाहती थी हमको हटा के.
So,
Therefore, it cannot be presumed because she has refused to take the rent. It means that there was stretching too far. That means there is a compromise. By compromise, the title had devolved upon the plaintiff's mothers, and therefore she is not accepting the rent. It's stretching too far.
That's
तो
ये हो गया इस पर. और उस पे क्या बोलना है आपको? Second substantial question of law. क्या आपका जो finding दिया है?
लाइसेंसी वाला.
Licensee वाला.
लाइसेंसी वाला पे हुजूर हम ये कहेंगे कि since we have said license, neither we have produced any document.
No document has been produced,
Yes.
but you were occupying the premises.
Premises
Let
on a
us
vacant
assume
land.
that it was on a vacant land.
It's not presumed
It
that
was
they have
your
admitted
case.
it.
Yeah, they have admitted it. Now you constructed a structure on that,
Yes, yes.
and then you paid rent for the vacant land as well as
The constructed
So
construction.
the judgment which they have cited, that still that brings you within the
Within the
definition
purview of
of
BBC.
BBC.
Therefore, initially हम कहे हुजूर को हम BBC में ही confine करते हैं इसको. उस पे हुजूर हम मेरा खाली argument लिख के उसको हुजूर अपने हिसाब से करते हैं इसको. But first substantial question of law, it is not
That will
perverse.
clinch the issue.
I got you.
That will clinch the issue.
हाँ, it is not perverse. The appellate court has
They
taken
have
care
failed
of.
to prove their title
Yes.
in absence of the decree and in absence of further evidence.
Yes.
That's
और
all.
वो judgment को standing point पे. और दूसरा वो जो हम दिए हैं कि the deposition of the person concerned, the main person, is much more required because she will only say whether there was a compromised degree or not. It is in her personal knowledge.
डिग्री हुआ तो डिग्री तो आना चाहिए ना.
हाँ, कहाँ है?
नहीं, अगर उनका ओरल एविडेंस भी नहीं चलता.
कुछ भी नहीं चले. हम एक बात कह रहे हैं, just sake of argument, उनको कुछ भी तो बताना होगा कि हमारी मौसी थी, हम लोग को दे दी कुछ. She has not come at all. So these are the adverse inference to be drawn by the court. And even Kanis Fatima, why she was shying up?
That's it. Anything you have to say? That's all. सुनिए आपको काफी. अब ऐसा है, हम जजमेंट प्रोनाउंस कर देते हैं, 2-3 दिन में अपलोड हो जाएगा. इतना लंबा हम कोर्ट में नहीं लिखाएंगे.
Time नहीं है.
Yes. I dismiss this. Judgment will be uploaded. It will take time. एक हफ्ता वेट करेंगे. Dictation देंगे, correction करेंगे. But I am not satisfied. हड़बड़ाइएगा मत.
नहीं.
Certified copy यहाँ पर
आराम से
रखिए.
आएगा.
I take my time.
वो जो एक सुप्रीम कोर्ट वाला था ना, वो अभी अपलोड हुआ है, जस्ट अभी भेजे।
कौन सा?
एक उस 20 तारीख को डेट फिक्स है, एक सब्सटेंशियल क्वेश्चन ऑफ लॉ
हाँ,
में।
वो छुट्टी के बाद शायद 3 तारीख को अपलोड हुआ।
हाँ,
वो रह गया।
अभी हम भेजे हैं अभी,
कोई बात
तो हो सकता है कि उस समय आए।
हाँ, हमको याद है,
जी।
हमको इनफैक्ट वो छूट गया था हमसे, क्योंकि हमको लग रहा था आप सुप्रीम कोर्ट जाने वाले हैं।
जाना ही था, उसको तो कोई ऑप्शन नहीं है मेरे पास। हम तो एक कंसीड कर गए हैं कि उसमें अगर वो नहीं है तो कुछ नहीं।
कोई बात नहीं, कुछ तो जाना चाहिए सुप्रीम कोर्ट।
बिकॉज लेंथी आर्गुमेंट की कोई आवश्यकता नहीं, व्हेन वी नो द लॉ, भाई कहाँ कंसीड करना है वो हम लोग को करना चाहिए। अब
इसको जरा रखेंगे थोड़ा सा। कौन है यहाँ पर? अटेची आपकी सैनिटेशन में कल किसको कुछ लिखाए थे? आपको लिखाए थे?
From date list for orders we defect item 2, Review 60 of 2021.
Defect. Civil Review 60 of 2021. Nobody applies on behalf of document. Yeah, ये pending नहीं है ना? Praying to keep in.
Data is for
क्या चीज़ है? Time till 29th of January is granted to the applicant to remove the surviving defects pending. If the defects are removed within time, pose this case on 6th of February. Let a soft copy of this order be communicated to the Council for Mediation.
Item 3, CMP 597 of 2023.
Absence record. Yes. ये भी डिफेक्ट है?
जी।
Same order.
Item 4, CMP 235 of 2024.
Yes.
This is restoration of CMP and CMP. There is two IA pending. IA number 8262.
Restoration matter of CMP. CMP square.
CMP
Square or cube?
square.
Square.
Two IA is pending.
What has been dismissed?
CMP has been dismissed. CMP number 714.
It was arising out of what case? First
Second.
appeal, second appeal.
Second.
Second appeal number?
Second appeal number is 279/2009. Second appeal number 279/2009.
Why was the restoration dismissed?
That was the order of Honorable Mr. Justice Anand Tiwari.
Why was it dismissed?
Non-prosecution of non-compliance of preemptive order. Order dated 31/7/2010. Thereafter the MPA has been filed for
31/7/2010. कहाँ है लिखा है 31/7/2010 का order? 2009 का सेकेंड अपील रेस्टोर हम इतना आसानी से नहीं कर पाएंगे।
there is delay of 1707 days.
बहुत अच्छी बात है। इसका एक और ये CMP था ना 714, इसका एक और होकर कनेक्टेड है। पहला CMP कौन सा था?
सबसे पहले CMP 714
ये पहला CMP था।
हाँ वो पहला था, उसके बाद ये दूसरा है।
अच्छा, this CMP was dismissed when you did not appear, correct?
That all files के लिए restoration of identity page number 4
आपको नोटिस हुआ था, you did not comply. ये
re-entry order was 31/7/2010 that has not been complied by that. Due to that, the second
CMP order कौन सा था dated?
dated 31/7/2010
In which case? SA
ऐसे
was admitted. It was also barred by limitation. What was the suit for?
in fact I don't have that.
वो नहीं पता होगा आप लोगों को। 2009 का ऐसे
Matter with
2009 का ऐसे डिसमिस करा के जो है ना 2029 पहुंचा दीजिए इसको। 20 साल हो जाना चाहिए, इससे कम तो नहीं होना चाहिए। 20 इयर्स तो स्टैंडर्ड है झारखंड हाई कोर्ट। Is it still defective or defect nothing to do? बहुत अच्छी लिखिए CMP नंबर 235 of 2024।
at least in the matter of limitation we will notice with
बिना डिफेक्टिव
the I is cycle for leave के लिए another one for
क्या
limitation.
लिखिए?
There is a defect of CMP number 235/2020
Yes.
for substitution of the petition appellant. I filed the I number 16896 of 2025.
What is the surviving defect in this case?
Only one defect.
Which one?
One for limitation and the other one for substitution petition. Defect was pointed out by the staff.
Defect number 9. Petitioner number 2 and 6 of the connected
Yes,
case have not been made parties in this appeal.
For that I have filed leave.
What leave?
I number 16896. For deletion the name of appellant number 2 and appellant number 6. As both have been died,
When?
I have annexed Annexure 1 and Annexure 2 of the certificate issued by the मुखिया। प्रमाणित किया जाता है कि स्वर्गीय शीतल महतो that is the response appellant number 2 झारखंड की मृत्यु दिनांक 15/4/2020 को हुई। My first CMP has been dismissed on 2017.
तो इनका क्या कोई लीगल हियर नहीं है?
Legally already record में है।
अच्छा, दूसरे कब माने? ये तो 15/4/2010
Exact दूसरे का exact date नहीं बताते हैं। Election 2 में लिखते हैं कि इनकी मृत्यु इशू की है फॉर्म सर्टिफिकेट की 24/10/2024 को, कि आज से 10 वर्ष पूर्व एग्जैक्ट डेट नहीं बता पा रहे।
10 वर्ष
10 वर्ष
तो 2014 में ही हो।
2014
तो आपका सब्स्टिट्यूशन में भी आपने रेस्टोरेशन में भी नहीं फाइल किया।
डिसमिस फॉर डिफॉल्ट वाज 2017, देयर आफ्टर फाइल हुआ आफ्टर डिले ऑफ 1770।
नहीं, तो डिसमिस फॉर डिफॉल्ट 2017 में हुआ।
सीएम
सीएम तो उसमें भी तो आपने नहीं फाइल किया ना सब्स्टिट्यूशन। इनके भी लीगल इयर्स रिकॉर्ड में,
इनके लीगल ईयर रिकॉर्ड में और जो इनिशियल appellant नंबर 2 है उनके लीगल ईयर को रिकॉर्ड में लाने के लिए लीव में प्रेयर एक जिनको हम पार्टी बनाए थे, बट ड्यू टू स्टाफ रिपोर्टिंग हमको डिलीट करना पड़ गया। एज appellant नंबर 2 प्रवीण कुमार वर्मा, लीगल ईयर ऑफ रिस्पोंडेंट नंबर appellant नंबर 2।
the cost title of CMP number 714. ये 714 का CMP में इसमें कैसे वो होगा? You are seeking a leave to delete the name of these persons from the cost title of CMP number 714. उसका उसमें थोड़ी होगा, उसमें तो अभी जब रेस्टोर होगा तब होगा ना उसमें, तो इसके लिए आप क्या करें? इसमें कैसे हो जाएगा?
उसमें डिलीट करने का
उसमें कैसे होगा?
डिफेक्ट को रिमूव करने के लिए उसको
नहीं, पहले तो ये रेस्टोर होगा तब होगा, ऐसे थोड़ी होगा. Unless this is restored, it is one thing to say that you want to pursue it irrespective of this fact. Praveen Kumar Verma is the petitioner before this court.
Earlier I added the appendix number 2, you see MP number 235 which is in hand. But due to defect, as per stamp reporter, I need to delete the name of Praveen Kumar Verma and add in appendix number 2 in CMP number 3.
ये सब अपीलांस है ना?
ये सब है.
इनके लीगल ईयर्स का वकालतनामा फाइल करें? इनको नोटिस थोड़ी करेंगे यहाँ से, पहले लीगल ईयर्स का वकालतनामा.
लीगल ईयर एक ही है, प्रवीण कुमार वर्मा, इनका प्रेस वकालतनामा फाइल कर देते हैं.
हाँ भाई, दो अपीलान भरे ना?
हाँ, दो अपीलान भरे, एक
उनका
का
फ्रेश वकालतनामा खुद से फाइल करिए, हम क्यों नोटिस करें यहाँ से? आपका इतना पुराना केस है.
हम फाइल
एक ही फैमिली के है सब?
सब एक ही. प्रवीण कुमार वर्मा के फादर का डेथ हुआ और उनकी दादी का डेथ हुआ.
पूरा खानदान का डेथ हो जाएगा आप लोग के कंडक्ट से. हंस रहे हैं, कुछ नहीं है. 2009 में डीएफडी करा के छोड़ आपने आप
2024 में कॉन्ट्रैक्ट की क्लाइंट हमारे पास दे रहा है.
वही ऐसे ही वकील बदलते रहिए और लिटिगेशन चलते रहेगा यहाँ.
2024 में मेरे पास आया था फाइल.
हम तो लिटिगेशन की बात कर रहे हैं. ठीक है, 2009 का सेकेंड अपील डीएफडी करा के 2024 में रेस्टोर कराइए. और जिस एक को भी नोटिस करेंगे ना, सब मर चुके होंगे, एक भी बच्चा नहीं होगा इसमें से. और ये केस जो है हम लोग के यहाँ पर हाईकोर्ट में चलते रहेगा फॉर अनदर 30 years, क्योंकि किसी का सब्स्टिट्यूशन आप कर नहीं पाइएगा और केस कभी मैच्योर नहीं होगा. यही तो है यहाँ पे सिविल लिटिगेशन का कहानी. Thousands of cases are pending without a date. स्ट्रीमलाइन करते करते 1 साल बीत गया. IA number 16896 of 2025 in CMP number 235 of 2024. The learned counsel for the petitioner submits that he shall seek instructions and file wakalatnama on behalf of the legal heirs of appealant number 2 and appealant number 6 who have expired who have already expired. वकालतनामा फाइल करिए, नोटिस नहीं करेंगे. कितना टाइम चाहिए?
4 weeks.
पोस्ट ऑन 13 करिए.
Item 5, second appeal filing number 13430 of 2024.
Project I is filed for extension of time, filing certified copy of trial court judgment. Now, where a PJ without certified copy of trial court judgment is filed.
Has been filed. तो इन्फेक्शंस हो गए. I number 178 of 2026. Counsel for the applicant has submitted that this interlocutory application has become infructuous as a certified copy along with authentication key has been filed during the course of the day.
Today I have.
Has already been filed. I number accordingly I number 178 of 26 is closed. और क्या है इसमें? अभी तो वहाँ स्टैम्प रिपोर्टिंग होगा फर्दर. Office to proceed as per law. Post this case on कब चाहिए बताइए? 3rd of February.
Item 6, second appeal file number 13642 of 2024.
Well, certified copy of trial court judgment and decree and other things is only required. Remaining defects have been required, removed. Only 2 weeks further extension of the time. All
ट्रायल कोर्ट और एप्लेट कोर्ट डिग्री का दोनों का सर्टिफिकेट ये क्या है सर्टिफाइड कॉपी
वो
एप्लेट
जजमेंट डिग्री बाद में बना था.
टाइम till 28 January is granted to the applicant to remove the surviving defect pending.
Yes.
If the defects are removed, post this case on 3rd of. If this order is complied, post this case on 3rd of February.
Item 7, second appeal file number 1935 of 2025.
Trial court as well as appellate court have the childhood name of the party. So I have received a fresh decree and filed it through an IA number 711.
Received a fresh decree.
Yes, sir. But you can take a look to page number 10 of IA number 711. And as per fresh decree, I have corrected all the name of the parties.
Fresh decree has been prepared.
इसमें ट्रायल कोर्ट और अपीलेट कोर्ट में सबका बचपन वाला नाम है.
हाँ.
और जब हम सेकेंड अपील फाइल किए तो वो एज पर डॉक्यूमेंट्री नहीं है, तो डिग्री को करेक्ट करवा के
जब rectified got the
Yes.
rectified.
and according to that I have corrected all the names in the second appeal.
IA number 7114 of 2025. So the defect has been removed. Ignore क्या करना? Ignore क्या करना? Defect has been removed as per the fresh appellate court decree. Correct? The learned counsel for the appellant has submitted that a fresh appellate court decree has been annexed along with the interlocutory application by which the names of the appellants have been incorporated. He submits that the memorandum of appeal is in accordance with the fresh decree. And accordingly, the defect has been removed. Office to check, IA closed. Post on 15th January.
Orders item 8, first appeal 120 of 2011.
I have complained on the last one. I did not have the money, but this will not just about work with.
There 5 वकालत number 4. Notice was issued to respond number 1.
1 and 2. I think yes, legal answer, respondent number 1 and 2. I am consultation of the legal heirs of the financial respondent.
Yes, respond number 1 has appeared.
Respondent number 1 and
Respond number 1.
process of the
देखिए FA number 120 of 2011. As per the office note, the notice sent through speed post to propose respond number 1A and 1B has been received. has been noted by stating that the same has been returned as the addressee was not found. Counsel for the appellant prays for and is granted time till 9th of February 2026 to take appropriate steps for fresh service of notice upon the aforesaid respondent number 1A and 1B at their present and correct address, or to file an appropriate petition seeking substituted service of notice. Print. Post this case on 9th of March. You speak first. Huh? Either you take fresh steps at their current and present address.
Address is same, my lord.
No, they have said that it does not stay over there.
Article 9 CMP 381 of 2018.
Is it effective? Yes. As per office note, OP number 1, 4 and 5 have expired. And their debt certificate has been enclosed. With the service. Naresh Singh is said to have expired on 18/7/2022. Padmavat Devi is said to have expired in the year 2018. Minor Naresh Singh is said to have expired on 18/7/2022. इन लोगों का ना डेथ का रिपोर्ट है. Apparently, the present proceedings has submitted in connection with the aforesaid office of finance. Notice upon OP number 2 and 3 has returned unserved by stating that they are not living at the given address. Time till 9th 28th of January is given to the applicant to take appropriate steps for service of notice upon OP number 2 and 3 through speed post at the current and present and correct address, or to file an appropriate petition seeking substitute service of notice. OP number. Somebody has notice to OP number 2 and 3 also returned unserved as they are not living under given address. ठीक है? Pre-entry. Post on 16th of February. Appellant absent taking it. Let a soft copy of this order is forwarded to the council for document.
Item 10, second appeal vote 148 of 2019.
Yes.
This is issued in IN 2457. Respondent one and right. And para 3 of the time we had mentioned the legal representative of PC respondent one.
Notice was issued.
Is my directions okay?
You have appeared.
I am appearing for the respondent number, legal year respondent number 126, 2N and 227.
Respond number. You are appearing for.
Respondent number, legal years of respondent, this is respondent one, Roman 1 to Roman 6 lords.
Okay. 1, 1, 2, 1, 6.
Lords.
And
2 to 7.
2 to 7. All of them have appeared. कोई बच्चा है?
Respondent one had left 6 legal representatives behind.
Okay. So substitution is to be allowed.
Date of death has not been mentioned.
That means that we are.
तो आप भी तो हैं. आप बताइए कौन सा डेट ऑफ डेथ है? लीगल ईयर है तो डेट ऑफ डेथ भी नहीं बताइएगा.
इनको बता देंगे.
बताइए.
हमसे पूछते तो बता देते हैं.
पूछते मतलब कहीं फाइल एंड एफिडेविट देखिए. ऐसे नंबर 148 of 2019. Counsel for the parties are present. Counsel for the respond number.
ठीक है अलाउ कर दीजिए. फिर अभी उनको बुला के.
Unnecessary है ये सब. Have
नहीं,
you
अगर
said
पूछते
that
तो
we filed during the pendency of this appeal? इतना तो लिखे हैं कि
हाँ,
ये
during the
नहीं
pendency लिखे हैं.
कहाँ
लिखे
है?
हैं. नहीं लिखे हैं. लिखे हैं during the pendency हम पढ़े हैं.
Okay.
He is that
लिखिए. This is IN number 2457. 2457 of 2025. This petition has been filed for substitution of respond number 1 for and also for setting aside abatement and condonation of delay in filing the petition. The respond number 1 is said to have expired during the pendency of the second appeal. It has been asserted that the exact date of death of respond number 1 has not been mentioned as the appellant could not find out the exact date of death. Notices were issued. The counsel for the appellant has submitted that the second appeal has remained pending since 2019 and it is an admitted second appeal?
No, will come under.
Since 2019 and the substitution be allowed. And it has also been mentioned that the application has been filed within time from the date of knowledge of death of respondent number 1. Notices were issued. The counsel for the respondent number proposed legal heirs and successors of respondent number 1 has entered appearance by filing wakalatnama. Rather, he has entered appearance on behalf of all the respondents in the present case.
Lords.
Right? He has no serious objection so far as substitution is concerned. However, he has stated that the date of death has not been mentioned by the counsel, by the appellant in the interlocutory application. After hearing the learned counsel for the parties and having gone through the interlocutory application, it is not in dispute from the side of the respondents also that the respondent number 1 has expired during the pendency of the second appeal, which has remained pending before this court since 2019. Being satisfied with the cause shown and being satisfied with the amendments made in the interlocutory application, the prayer for substitution of respondent number 1 is allowed. The abatement is set aside and a delay is allowed. और बताइए
Next week, what about
jointly आपको तो क्या ही काम है
इसलिए jointly नहीं लिखा है.
counsel for the appellant नहीं post this case under appropriate heading on 15th.
Item 11 CIP 351 of 2019.
There are two interrogatory applications. One relates to the confirmation of delay. Another relates to denote the defect number, to explain the defect number 10, as directed by the Lordship on 10th July 2020. But so far defect number 10 is concerned, what happened? The first appeal was filed by the father of the appellant. The first appeal was admitted, work records were confirmed, it was posted for hearing. He then lawyer who was representing the father of the petitioner, he could not appear, therefore it was dismissed for default. Now that information was not given. In the meantime, in 2017, that was on 14/1/2016, mother of the appellant died and the father remained in coma, he was a aged person, and he also died in 2018 after dismissal of the first appeal.
Mother and father both.
So his remaining legal heir is the petitioner. Now he who come to know about the dismissal relatedly in 2019, then he filed this application for restoration. The office pointed out that he was not a party in the first appeal. Obviously not. The first appeal while the father was alive. Now I have explained this thing not, if you also may kindly see IA number 10981 of 2025. 10981 of 2025. That is in respect of the defect not remain.
When was the first appeal dismissed?
Yes. On 14/1/2016. 14/1/2000. In this I have explained not everything. You also may kindly have a look. Paragraph 5 onwards. That rather not. Paragraph 6. That the mother of the appellant died, and thereafter father died from she was suffering from kidney problem. Ultimately, father of the appellant died on 7/6/2018.
When did the mother die? Anyway, that date is not there.
In 2017. Limitation section जो होती है 861. 8961.
On behalf of
RRD and state both were parties.
only they were parties or they are private parties also?
No.
Any objection?
there is a delay of 1180 days process, and as the counsel for the petitioner said, that the father of the petitioner died on 7/6/2018, Lordship. But this application in para 10 of their IA, they have themselves stated that this application was preferred on 9/5/2019, Lordship.
Yes.
After almost a year, Lordship.
This was not, I have also explained.
Delay is also unexplained, Lordship. And on the last occasion also, the counsel for the petitioner was not
Good one?
Not
It
present
was adjourned.
That is-
on 26/9/25.
What is the matter?
Matter relates to the title suit was dismissed. Against it, first appeal was prepared. Appeal was admitted. Lower court records were called for. It was placed for hearing.
Appeal itself is of year 2004.
I'm ready to cooperate now because it is unfortunate, and I have explained what the delay in 8961 IA number. I have served the copy also. No reply has been filed. Still, Mirror, Jharkhand has right to oppose. Lordship may kindly see. On 14/1/2016,
You
the
see, on 14/1/2016, the first appeal was dismissed.
dismissed.
Then you say that the council did not inform you. Did you contact the council?
Because the father was the party and he was alive at that time. He did not.
He did not. You see, if the father does not contact his council, then after 2 years, 3 years, 10 years, the some will say that I have no information.
Intervening circumstance.
What is
Lordship may
it?
kindly see, he due to old age and kidney problem, mother of the petitioner died.
Yes.
Then after
Who was the council? Who was the council who did not?
I have said in para 7 that neither the petitioner nor his father had any information about the order dated 14/1/2016.
Who was the council in this first appeal?
Mahavir Prasad.
Where is it? See, वो तो नहीं आएंगे ना, नए काउंसिल आएंगे, रेस्टोरेशन फाइल
इसका
करेंगे।
सर्कमस्टेंस दिखा है।
क्या circumstance दिखा है?
16/6/17 को माँ मर गई। उसके बाद उनका
16 से 17 को कहाँ मरी, कहाँ लिखे?
पैरा 5 ऑफ द लिमिटेशन 8961।
माँ से क्या लेना देना है?
बता रहा हूँ, उसका ट्रॉमा में ही चले गए। ओल्ड एज है, एज भी देखा जाएगा। And after the death of his wife and out of ailment, going to old age, the father of the petitioner, being appellant number 1 in the first appeal, who died after long treatment on 7/6/2018, and thereafter, after observing all ceremonials going to such death, the petitioner went to the council appearing in the first appeal to ascertain its status on 3/5/2019, and then only the learned council appearing in the appeal and ascertain such position of the appeal and inform the petitioner that the same is to dismiss due to his non-appearance. Bona fide. Thereafter, the petitioner preferred this application on 9/5/2019.
Even after the death of the father in the year 2018, there is delay of almost 1 year.
11.
Preferring this appeal.
Yes, there was delay. I explained, Lord, that the petitioner was not pursuing because he was not aware about this. Then after death
He was not aware of what? About the first appeal.
about the dismissal order. Otherwise, he could have pursued, very well pursued.
Okay, he was not aware about the dismissal order,
Then
but he
after-
was aware about the death of his father.
Yes, yes. Then thereafter, Lord, he approached on
So you
3/5/2019.
can approach at any time you want.
Lord,
At least, you see, if your father was dead, then under such circumstances, was it not your duty to approach the council?
there are Lord, at least in Dhanbad 45 cases filed by the father of the appellant petitioner for eviction of 45 tenants. Thereafter, Lord, this is one of the cases. Lord, this is also one. At least 45 to 50 cases were pending. Now, in order to accumulate all these information and the records which were lying in different advocates, then there has been some delay. It is not this single case, Lord, which was being pursued by the party.
ID number 10981 of 2025. This petition has been filed in connection with defect number 10. The council for the petitioner has submitted that the first appeal number 1 of 2004 was admitted on
That was admitted.
on 26/3/2004.
Yes. 26/3/2005.
And after more than 10 years, it was listed for hearing on
14/1/2006.
on 14/1/2016. देखिए तो एक ही दिन में हो गया डिसमिस. उसके बाद सीधे 14/1/16 को डिसमिस हो गया केस. I think so. The admission card, right?
तो 25/8/15 के बाद एक बार लिस्टिंग हुई थी, उसके बाद 14/16 as per the
And lastly, us लिखिएगा it was admitted on 26/3/2004 and lastly it was listed on 31/7/2008. नहीं, lastly
14/16
and thereafter it was listed on a few dates. And on 21/11/2013, it was brought to the notice of the court that the conducting advocate has left practice at Jharkhand. And notice was issued to the appellant. But ultimately none appeared and the case was dismissed for non-prosecution on 14/1/2016. फादर का डेथ कब हुआ?
7/6/2018
नोटिस तो हुआ था आप लोगों को, आप एक्टिव नहीं हुए. नोटिस हुआ था आपको, आप एक्टिव नहीं हुए. देख लीजिए मिस्टर सानी, हम नहीं करेंगे. अभी ना प्रश्न क्या बोनाफाइडी है सर? आपको यहाँ से कोर्ट से नोटिस जा रहा है कि आप दूसरा वकील एंगेज कर लीजिए. सर्विस रिपोर्ट है एंड यू डोंट टेक केयर. इसमें क्या बोनाफाइडी? कोई बोनाफाइडी नहीं, कोई ट्रॉमा का बात ही नहीं है. नहीं, एक आध केस ये सब ग्राउंड में आपको डिस्कस करने दीजिए. कुछ एकदम गलत. केस जेन्युइन होगा, कंडक्ट जेन्युइन नहीं है.
16/6/17 को उनकी पत्नी की डेथ हुई, सही. उसके बाद इनका डेथ हुआ इमीडिएटली ऑन 7/6/18
17 को. ये जो यहाँ पे ये जो लिखा हुआ है कि उनको सर्व किया हुआ नोटिस इन द ईयर 2016.
16
Your father did not take any steps to pursue this case.
तो मर गए मुझे तब तो बाद
मर गए ना बाद में.
मर गए थे. इनको पिटिशनर was not aware about this fact. Really, this is the situation and there are at least 50 cases.
सभी केस ऐसे ही डिस्कस करें.
नहीं ऐसा नहीं, वो सब तो पेंडिंग है. उसका सब्स्टिट्यूशन वगैरह हो गया, एग्जीक्यूशन केस हुआ, वो सब चल रहा है. ये केस में जो 16 को डेथ हुई, 17 को 16/6/17 को माँ का, और उसके इमीडिएट बाद जो है 17/6/18 को उनका डेथ हुआ फादर का. उसके बाद ही जब सर्च किए, सब कुछ देखे कि ये केस भी पेंडिंग है, तब कॉन्टैक्ट किए. अब कॉन्टैक्ट किए तो 19 में कॉन्टैक्ट किए, 18 के बाद 6 महीना बाद.
थोड़ी आगे सेकेंड हाफ में देखेंगे. सेकेंड हाफ बेंच कंटिन्यू है ना.